You're watching Ticket TV. Like, share, and subscribe on your way in.
Shout out to Quanti's Records. Appreciate you with the $100 donation, my brother. And salute to you for supporting the channel and everybody else that supports what we got going on and what we doing, man. I appreciate all of y'all. After 30 years, man, after 30 years, we come to this day. A lot of speculation has went on over the years about what really happened in the murder of Tupac Shakur. And after 30 years, we had one good cop that came out and exposed everything. And it's not what you think. Keefe D is going to be going to prison for the rest of his life. And the murder of Tupac Shakur with a gang enhancement attached to it. Today, the jury will be read their instructions. And in those instructions, the jury will be told that they don't need physical DNA evidence. Keefe D's own statements, along with the witness testimony that's been in that court, along with circumstantial evidence, is enough in Las Vegas to find him guilty. Yesterday, this police officer, Officer Dan Long, I salute Officer Dan Long because he knows what he did yesterday. Cops never supposed to do this, and that is throw other cops under the bus. But Keefe D's team made a major mistake. They called Dan Long to the stand. They thought that because Dan Long, who had joined the case around 2008, had personally not been able to follow up on leads from a murder that happened 13 years prior, they thought that that would be enough to show the jury that there was nothing there. But Officer Dan Long, one good man, he exposed LA cops and exactly what happened on the stand yesterday. He exposed it all. Dan Long, who was called by Keefe D's lawyer, who this was the biggest blunder in U.S. history, testified under oath that police officers and task force members, LA cops, were the ones that physically sat in that room during the interview and gave Keefe D an illegal proffer. Let me repeat myself again. Dan Long got on your screen with a devastated look on his face, a disgraced look on his face, because he knows that they were wrong. Dan Long exposed in court that the LA cops gave Keefe D a falsified proffer deal. The sad thing for Keefe D is that Keefe D does not know he can't do anything about it, and neither can Tupac's family. And I'm going to tell y'all why. And now I believe Tupac's family knew this going into this trial. I believe they were told this by investigators in Las Vegas, what happened with the investigators in California. To explain it to you guys what happened, man, is very sad. Because Keefe D's own witness turned out, and you can't make this mistake if you're Keefe D's lawyer. Huge mistake if you're Keefe D's lawyer. His own witness turned out to be friends or knows the prosecutor in this case. In fact, on cross-examination, they both greeted each other as old friends who had known each other for years. That destroyed Keefe D's case, and that explained why the Las Vegas prosecutors did not interview Detective Greg Kading and some of the other people that were involved from the Los Angeles cops. The deal Keefe D signed or agreed to, the proffer deal, was unauthorized. Keefe D's own witness, Officer Dan Long, that you see on your screen, in court yesterday, he revealed that the cops, what they were doing was they were going around and they were using leverage of people who were facing numerous years on drug charges and things like that to get them to talk about the notorious B.I.G. murder. Keefe D was a man of interest originally in the murder of the notorious B.I.G. Keefe D was there that night that the notorious B.I.G. got killed. Officer Greg Kading, when Biggie Smalls' mother, the late great Biggie Smalls, when his mother, Violetta Wallace, filed a wrongful death lawsuit to the person who says, I'm switching up. No, I'm not. You might want to shut up because Keefe D going to prison forever, boy. When Violetta Wallace filed a wrongful death lawsuit and accused the department of being involved in the murder of the notorious B.I.G., there was an officer. His name was Officer Greg Kading. And today, I'm going to tell you guys the entire truth. I'm going to tell you the entire truth. Because what the truth does is it sets you free and it keeps you free. This man I'm going to show you guys right now, Officer Greg Kading, he was assigned to a special task force unit to reinvestigate the murder of the notorious B.I.G., Biggie Smalls, because he had to find information as to whether or not cops were involved in the murder of the notorious B.I.G. because his mother, Violetta Wallace, had sued the department. Officer Greg Kading, along with other officers, what they would do is they would get certain gangsters on the street who maybe they caught up in the drug charges and things like that. And they would use that as leverage to get these guys to talk about the notorious B.I.G. murder. Greg Cady caught up and had charges on this man right here, Keefe D. He had charges on Keefe D for drugs. Keefe D was facing life in prison. Keefe D was found, as revealed in his courthouse, with a gallon of PCP in his car. Keefe D was facing the rest of his life in prison. They found out that Keefe D had been major moving, and they went to meet Keefe D at his house, I believe in his garage, and told Keefe D, you need to get a lawyer and come downtown. We need to talk to you because you got some serious stuff on you, man, and it's not good. But we could talk about it. At the same time, the reason why they didn't arrest Keefe D instantly for all of those drugs he had was because the Los Angeles Police Department at that time believed that Keefe D had involvement in the murder of the notorious B.I.G. They believed that Keefe D had a falling out with Bad Boy Records, and it was a money issue, and they believed that Keefe D had involvement in the murder of the notorious B.I.G. Keefe D is on numerous interviews speaking about that night when the notorious B.I.G. was murdered. In that interview, Keefe D stated that Puffy allegedly told him when he went over there, he said Big greeted him, but Puffy allegedly told him, hey man, back up off us, we got the feds all over us, bro. Is what Keefe D said that night that notorious B.I.G. was murdered. Shortly thereafter, the notorious B.I.G. leaves and is murdered right outside of the museum. Keefe D later says in interviews that if Diddy would not have pushed him off, they would have been able to protect Biggie that night to where nobody would have been able to kill Biggie. They would have held it down and they would have been able to get chased to whoever the shooter was. He basically said there's nothing happened. That nothing would have happened to Biggie that night if Diddy wasn't acting crazy and acting like he wasn't fucking with him no more and couldn't be around him. So the cops had it wrong. They didn't know that Keefe D had nothing to do with Biggie's murder at that time. But what the cops are going to do is, which was illegal, that got exposed in court yesterday by Officer Dan Long, and I salute Dan Long. Good man, bro. Good man on the left-hand side of your screen. Good man. Dude wanted to cry because the last thing you do is throw your fellow officers under the bus. But they did something dirty to Dan Long, and I'm exposed it all today. And I salute Dan Long. After all these years, the truth is finally out. So Keefe D, Greg Cady, tells Keefe D, come on, we need to talk. The agreement was illegal because Officer Greg Cady and the other officer that met with Keefe D did not have the power to give Keefe D a proffer agreement. And it was illegal and against Metro rules Because in Metro, you can't give a guy time off or shave off years on a body. It can only be a non-violent crime, like another drug charge or another drug situation. It couldn't be a sexual assault. It couldn't be a murder. It could only be for another non-violent crime that Keefe D was giving up information to the cops to help shave off his years. Keefe D routinely bragged about how I took the hit. I saved my team. I part of the Red Sea. I saved a lot of people like Moses. The cop admitted that Keefe D, he did take a major hit. But Greg Kading and the other officer, the black officer y'all saw testify, they were in for a rude awakening when they finally talked with Keefe D and his lawyer that day in that proffer that was illegal. The proffer was illegal. Now, before you guys say something about, oh, why is Keefe D? The problem is this. Keefe D can do nothing about it. And neither can Tupac's family. And it's sad. Because the police are allowed to lie. And I'll explain that in a few minutes. The police are allowed to lie. This shit's sad, bro. Keefe D gave up all that information. And the truth is, you guys, the only person that was authorized to give Keefe D a proffer agreement was a U.S. district attorney, not cops. But when they got to talking to Keefe D about the notorious B.I.G., Keefe D throws Greg Kading and the other officer, the black officer, a bombshell. Keefe D tells them in that meeting, we ain't had nothing to do with Biggie, man. That one wasn't us. And the officer asked him, if that wasn't you, there was only one other one. And that's when Keefe D agreed to give those cops in that illegal proffer the information that cops had already had. Cops could have already made an arrest, but they didn't. Keefe D gave them the information they needed. Greg Kading went on to get the information he personally needed with Biggie Smalls to be able to dissolve the lawsuit with Valetta Wallace and her thoughts with the cops being involved in the murder of Biggie Smalls. But there was another problem. There was a man who was assigned to the Tupac murder trial 13 years later. And he was a good man. And he's on your screen. His name is Officer Dan Long. And Dan Long wanted to work by the book and do things right. He had no idea that any of these illegal things had been done, or should I say, rule breaking had been done. He starts to investigate the murder trial. He gets enough evidence, and they're talking with Keefe D again. Him and one of the officers who had already talked to Keefe D when Keefe D had his proffer agreement. Now, Officer Dan Long had no idea that Keefe D had a proffer agreement. And when he went into that meeting, Keefe D must have got scared, shook, or something. Because when Dan Long went into that meeting, he was asked to walk outside the meeting, which left Keefe D's lawyer, and the other officer who had previously done the proffer agreement with Keefe D alone in that office. So Dan Long, who had taken his own recording, which is 100% legal, did not and was not able to record the part of when he was asked to leave out that office. But that was revealed in court. And the buddy, the prosecutor, who had the other recording that actually had the parts that Officer Long never heard, played those parts for Officer Long. And it broke Officer Long's spirit. He was asked to come back in the room at that time. After shortly stepping out of the room, I suppose Keefe D was given assurances that nothing was going to happen with whatever he said in front of this new guy. And Keefe D gave a full confession to the murder of Tupac Shakur. Information that the cops had already had for nearly 30 years. After that meeting, Officer Dan Long, having all of the information he already had due to their investigation into Keefe D and the murder of Tupac Shakur, he immediately went to write up a warrant for the arrest of Keefe D for the murder of Tupac Shakur. When he went to get the warrant approved to arrest Keefe D for the murder of Tupac Shakur, when he went to his higher-ups, they shut him down. Officer Dan Long could not believe it. He said, "What do you mean, shut it down? We got to arrest this guy. We already got all the evidence we need, and he's giving us a confession to match up with the evidence we need. What are you talking about? We got enough probable cause right here to arrest this motherfucker right now." Keefe D, the cops could have arrested him years ago and gave him Tupac's family justice, but they didn't. Dan Long couldn't believe what the hell was going on. So he went to find out, why in the hell can't I go down here and arrest this motherfucker? And Dan Long found out and was told, you need to fall back because of that proffer agreement. And it was so nasty, nobody wanted to own up to it. Nobody wanted to own up to that fuck up. Nobody. So to break down exactly what happened, I'm going to tell you this right now. Right? The U.S. Attorney's Office, they asked, right? Right? Or should I say, the lawyer asked if the U.S. Attorney's Office or the L.A. District Attorney's Office return their calls, meaning a prosecutor. He asked Officer Long on the left-hand side of your screen if the Los Angeles District Attorney's Office returned his calls to confirm that proffer deal. They would not speak to Officer Long. The task force officers basically acted on their own to get the confession after they found out what the hell Keefe D had. They just ran with it. They wasn't even talking about Pac. They was on a Biggie case. But since he gave him Pac, right then and right there, and the crazy part is they already had information to prosecute Keefe D for that murder. But the task force officers basically acted on their own to get the confession without proper approval from the U.S. District Attorney or any sovereign prosecutor, which is what they needed. That's the only way they could do a proffer. So because local police officers made a promise to Keefe D that they did not legally have power to lock in, the Clark County District Attorney in Las Vegas looked at the recording and realized that it was not a legally binding sovereign agreement for the state of Nevada. Meaning, after 30 years, this is why Keefe D is being prosecuted for the murder of Tupac Shakur. His own witness got his fucking lick back and exposed them dirty cops by doing it. I ain't gonna say dirty, but exposed those cops by doing it. Because former LAPD officer Greg Kading, detective I should say, Greg Kading, and his federal task force bypassed standard legal protocols by handing out an unapproved proffer agreement, the Las Vegas Metropolitan Police Department completely backed away from their investigation. At that time, it was fucked up, man. Officer Kading and his task force targeted Keefe D on federal drug charges, as I told y'all, to make him talk about the Biggie Small murders. He gave him Tupac. They gave him a proffer agreement without the required approval from a sovereign prosecutor like the U.S. Attorney's Office or a district attorney. When the Las Vegas homicide detectives listened to a secret 2008 and 2009 recording from Keefe D, they realized at that point that a group of out-of-state police officers had promised a murder suspect immunity without any legal right to do so. The Las Vegas district attorney immediately told the local detectives to stand down and refused to move forward with Greg Kading's unauthorized operation. And instead of working together, those agencies stopped communicating. Las Vegas Metro had tried to call the California Task Force and the attorneys to figure out what kind of deal had been made. But the California side did not return their calls. It's fucked up, man. And because Officer Greg Kading's task force ran an unauthorized deal that local prosecutors could not touch, Las Vegas Metro completely locked down their own files. The case sat frozen for years until Keefe D dumbass came out bragging about the murder in public interviews in a memoir. Keefe D thought he had a get out of jail free card with that proffer agreement. The proffer agreement was worthless. The deal was slapped together by California police officers and a federal task force. And because it was not a legally binding agreement approved by a sovereign judge or a prosecutor in Nevada, the Clark County District Attorney in Las Vegas was completely free to ignore it. They were never bound by what out-of-state officers promised Keefe D. A proffer agreement only protects the specific recorded words you say inside that interview room. It does not protect you if you go out and tell the rest of the world. Keefe D essentially blew up his own protections by writing that book, Compton Street Legend, doing countless YouTube and other media interviews and bragging about orchestrating the shooting itself, and participating in documentaries talking about his role in the murder. And because those public confessions were made completely outside of a police interview room, a Las Vegas judge officially ruled that Keefe D's book and his media interviews are fully admissible as evidence against him in the court of law. Officer Dan Long, who Keefe D's dumbass lawyer called to the stand, fried his ass yesterday, and it backfired. Officer Dan Long testified that he left that 2009 interview with Keefe D fully believing that he had plenty of probable cause to arrest Keefe D for murder, and that he intended to drive straight back to Las Vegas, type up a warrant, and put handcuffs on Keefe D for the murder of Tupac Shakur. The entire reason why he was blocked from doing that was because when the Las Vegas District Attorney's Office reviewed that audio and the transcripts, they immediately realized that the California task force officers had granted Keefe D a protected proffer. Because California authorities would not return the calls to Las Vegas Metro, the local prosecutors had no way of knowing how legally airtight that proffer was, meaning the LA department never called back Las Vegas. When Las Vegas kept calling to ask about that proffer, because it seems as if the LA higher-ups were protecting Greg Caden and those other officers who made that illegal deal. And this is the reason why, for all these years, Tupac's family never got any justice with an arrest. So because California authorities would not return to Las Vegas Metro's phone calls, again, the local prosecutors from Las Vegas, they had no way of knowing how legally airtight Keefe D's proffer was. And fearing that if they went and arrested Keefe D right now, at that time, would violate a federal agreement or compromise that case legally, the district attorney told Detective Long to stand down and don't arrest Keefe D, because they had to sort out what was a jurisdictional nightmare because of that proffer agreement. So to make it plain to y'all, Tupac was murdered in Las Vegas. He was under Las Vegas law. Keefe D got arrested in Los Angeles, California. Or he was going to get arrested. He was facing drug charges and facing the rest of his life. He gave a proffer, but it was illegal to give a proffer in Metro and use bodies, meaning murders. But because the cops did dirty, they used the information Keefe D gave them about the murders. The information he gave them about the murders of Biggie and Tupac was valuable information to them, because those cops, they didn't want anything to do with that wrongful death lawsuit that Violetta Wallace hit him for. That's why Greg Kading is even involved. They were just trying to get the Biggie situation resolved, which they did. They were able to prove and get through the evidence that those cops wasn't involved in Biggie's murder, which people still have a lot of questions about. But they were given a nugget. They were given Tupac's. But they were given it illegally. And because Greg Kading's bosses didn't want to jam him up or screw him over for what he did and how they did it, they just never answered Las Vegas for all these years, y'all. Las Vegas had been calling, trying to arrest Keefe D for the murder of Tupac Shakur all these years. But they could not find out the specifics about that proffer agreement. So they had no choice but to stand down because nobody would even talk to them from the higher ups in Los Angeles, California. So they had no idea. So if they would have went and arrested Keefe D for the murder as they had evidence, and Keefe D was already given a proffer agreement that was legal, it would have fucked the whole case, and Keefe D would have walked away a free man over legalities. But something else happened. Now, Tupac's family, you may think, well, they need to sue the police department. The sad part for Tupac's family is Tupac's family legally cannot sue the police department. And I know it sounds unfair, and it sounds that it's bullshit that an illegal agreement that froze that case for damn near 30 years cannot be sued to say. But the reason why Tupac's family could not sue is because the police have what they call qualified immunity, meaning under United States law, police officers and departments have protection. That protection, again, is called qualified immunity. That means that you cannot sue a police department just because they did a poor job, or they made a tactical mistake, or they accidentally botched a piece of evidence. To win a lawsuit against the police, Tupac's family would have to prove they intentionally violated someone's clearly established constitutional rights or committed blatant crimes themselves. Making a messy, unauthorized proffer deal is considered an investigative failure, not a civil rights violation against the victim's family. And also, you have discretionary immunity, meaning that the prosecutors in the case and the police have a legal right to decide when and how to charge a crime. And because the Las Vegas district attorney ordered to stand down to investigate the California legal mess, a court would view that as a protective legal decision and not a suitable defense not a suable defense. Let me say that, like something you could, a suable offense, I want to say something you could sue them for, right? And also the statute of limitation is gone. For that lawsuit against that government agency, the families usually only have 1 or 2 years from the date of the incident to file. Tupac's family trying to file a lawsuit against the LAPD or Las Vegas Metro for the decisions that they made in 1996 and 2008, it'll be thrown out immediately because statutes of limitations. So what did the family do instead? And this is why I believe the family was in lockstep and knew and was told what happened before this case started. Mopreme Shakur, the brother of Tupac Shakur, stepbrother, he filed a wrongful death lawsuit against Keefe D before this started. That civil lawsuit bypasses the police entirely. And they're using this to force a discovery, meaning that they can subpoena records, demand answers under oath, and unmask all the other unnamed co-conspirators who may have funded or helped organize that murder back in 1996. So Officer Long, who Keefe D, dumbass lawyer, called on the stand, he destroyed Keefe D. And right now, legal analysts are considering it one of the biggest legal blunders in the entire trial. Or strategic blunders, I'm going to say, in the entire trial. Keefe D's lawyer, by calling retired detective Dan Long as a star witness because he wanted to try to prove that there was a messy investigation, it backfired. And Detective Long's testimony completely blew up in Keefe D's face yesterday on the stand. Detective Long did a couple of things, you guys. He confirmed Keefe D's name dropped those real killers. Keefe D name dropped the real killers. So Keefe D's legal team wanted to argue that Keefe D's stories were just clout chasing and the nigga was just telling lies to sell books. But when Officer Dan Long was cross-examined by the prosecution, he testified that during their interview in 2009, that Keefe D accurately named the exact same 4 men that investigators independently knew were already inside that white Cadillac the night Tupac Shakur was killed. And this proves that Keefe D wasn't just making up random gang stories, but that he had real inside information. He also handed the prosecution probable cause. He wanted to highlight the 2009 stand down order is what he wanted to do. He wanted to highlight that, the 2009 stand down order, to make the police look incompetent for uncertain, right, in that case. But instead of doing that, Officer Long proudly told the jury that he personally believed that there was plenty of probable cause to arrest Keefe D for the murder right after that interview they had. That Keefe D had confirmed what they already knew through investigation. And by having Keefe D's own witness explicitly look at the jury and tell them that the defendant looked guilty of murder was a massive win for the prosecution yesterday. He also explained the delay logically. The defense spent that trial trying to make the 30-year delay look suspicious. Officer Long cleared that up by explaining that the only reason Keefe D was not arrested in 2009 was due to a jurisdictional mess caused by the unauthorized California proffer, not a lack of evidence. Not a lack of evidence. And also, right? Greg Kading. The true goal of that proffer agreement, as I told y'all, in 2006, the late, great, notorious B.I.G.'s mother, R.I.P. to Big, his mother, Violetta Wallace, she filed a massive wrongful death lawsuit against the city of Los Angeles. She claimed that corrupt, rogue LAPD officers working for Suge Knight helped orchestrate her son's murder. To protect the city from that multi-million-dollar payout, the LAPD built a federalized task force and explicitly put Greg Kading in charge to solve the Biggie Smalls murder and disprove the theory behind Violetta Wallace's lawsuit. Greg Kading's task force caught Keefe D trafficking massive amounts of drugs. They had him facing life in prison. To the brother in the comment section, he's not beating this. You don't have any brains and you don't know what you're talking about, sir. You're completely stupid. You are. He did not admit there were no facts, you damn fool. And I'm going to play the video after this. He said that when he got on the case in 2013, he personally himself could not verify those details personally from 14 years ago. But that his other officers that were on the case did, you dumbass. Go back and listen to what he said in court. You fool. He said he personally, because he came on 13 years later. He said when he tried to talk to DeAndre Smith told him to fuck off and he walked away. When he tried to talk to Suge Knight hung the phone up. But he said that they had already investigated and had the evidence already against Keefe D and the other guys that were in that car. Go listen to what he said, you damn fool, before you come on here running your rabbit ass mouth. We're going to play it for you to make sure you understand better. So, Greg Kading, task force. And ladies and gentlemen, this is what you call the epitome of stupidity in the comment section. We are on trial and they never presented evidence Keefe D was in Vegas. You dumbass. Are you not listening? Keefe D's own admission is just as good as evidence proving that he was in Vegas. Are you not an idiot? Are you an idiot or not? Go read Las Vegas laws, you asshole. You're a dumbass. You're literally a dumbass. You're gonna look stupid too. Let me get you out of my comment section. So Keefe D's, Greg Kading's task force, they caught Keefe D trafficking a large amount of drugs. And they had him facing life, as I told y'all. And Kading and Officer Darren Dupree sat Keefe D down, hoping that he would confess to helping orchestrate the Biggie Smalls murder in Los Angeles. Instead, Keefe D, as I told y'all, he threw him a curveball. He denied Biggie, but he offered a full confession on how him, his nephew Orlando Anderson, killed Tupac Shakur in Las Vegas. So, when they got that information, Greg Kading and them, they couldn't let that go because that had something to do with Tupac. They're like, hold on, we got some Tupac shit. So instead of them doing what the fuck they were supposed to do, which was run to the higher ups and get that proffer approved, they said, nah, fuck that, we gotta do this right now while we got him right here. And they gave him, those two officers, an illegal proffer. Kading and Dupree ran with the proffer agreement right then and there. But because they were single-mindedly focused on their own California task force goals, they failed to secure an official cross-state sovereign clearance from prosecutors in Nevada. You fucking idiot. Remember, Tupac was murdered in Las Vegas, not California, dumbass. So, Greg Kading, he got the confession, which allowed him to map out the theory that Biggie was killed in direct gangland retaliation for Tupac Shakur, not by cops. And once the task force gathered enough evidence to show that the LAPD wasn't legally responsible for Biggie's death, Valletta Wallace's lawsuit fell apart, and Greg Kading's superiors abruptly shut that task force down. Because the proffer was handled so poorly, you guys, and selfishly by the state of California, the Las Vegas Metropolitan Police felt completely undermined, and they refused to touch Greg Kading's unauthorized file for a decade. Now do you get it? Now do you get it? Right? Keefe D is fucked with no Vaseline. Because even though that proffer they gave him was bullshit, police trickery is legal. Under the law of Las Vegas, Keefe D is completely blocked from using the fake proffer card for these major reasons I'm about to tell y'all right now. Number one, in the United States of America, you guys, it is entirely legal for police officers to lie, for police officers to exaggerate, or for the police officers to use trickery during an interrogation to get a suspect to confess to the truth. Even if the California task force officers misled Keefe D into believing they had the power to give him total immunity, the law says it was Keefe D's responsibility and his lawyer's responsibility to make sure that that proffer was signed off by the U.S. attorney, and they didn't. And because they didn't sign off on a deal that locked in a cross-state line deal, the agreement wasn't illegal. It just wasn't legally valid or invalid in the state of Nevada, which is why Keefe D is about to get life in prison, you dummy. And Keefe D ruined his own legal defense. Even if that proffer agreement had been 100% legally airtight, with no problems, Keefe D destroyed his own protections the minute he started doing interviews on Vlad TV, Art of Dialogue, and other public outlets. A proffer agreement is very specific. It only promises that the exact recording made inside of the police room cannot be used against you in court. It does not protect you if you walk out the room, write a memoir, do interviews on YouTube, or do documentaries with filmmakers like Keefe D did. And because Keefe D spent years bragging about the murder on public platforms for fame and money, the judge ruled that all his public interviews and books are fair game to be used as evidence, you dumb son of a bitch. That's why they don't need no gun. That's why they don't need DNA. That's why they don't need fingerprints. That's why they don't need no car. Because they can use Keefe D's own fucking words, which is what they did, along with circumstantial evidence to go along with those words. Right? Officer Long was so ashamed, you could see the tension coming through him on the stand. And for a man who spent 17 years in homicide and took pride in building clean, lawful cases like Officer Dan Long did, it was deeply saddening and uncomfortable for him to air out police dirty laundry in front of a jury. Law enforcement culture relies heavily on loyalty and teamwork, you guys. Right? Loyalty and teamwork. Loyalty and teamwork. Think about what I just said. Loyalty and teamwork. Right? Officer Long had to sit on the witness stand and openly admit that a fellow task force, cops he knew and had to travel to go see, ran an unauthorized, sloppy operation that paralyzed a historic murder investigation for decades. Him exposing that level of incompetence in another police agency goes against every instinct that a veteran police officer has. Officer Long, he clearly wanted to lock Keefe D up in 2009. He testified that he felt he had plenty of probable cause to do so. You could see the professional shame he had on his face. That such a high-profile homicide investigation, you guys, was forced to stand down. Not just because of bad detective work on his end, but because of outside officers who wanted to cut corners to protect their own city's lawsuit. So it was a stark moment in front of the jury A sad moment of a good cop having to admit under oath that the system completely broke down from the inside. He also did one other thing that F Keefe D to the utmost. Keefe D's defense strategy was to paint the entire 2008 and 2009 confession as total fiction, meaning it wasn't true. That he just made up a lie to save his own skin on drug charges and eventually sell a book by it. But by dumbass Keefe D's lawyer and Keefe D calling Detective Dan Long to the stand, they wanted to show by using Dan Long that the police were incompetent and could not independently verify many of what Keefe D's claims were in all of these interviews he was doing on YouTube and online. But when Officer Long started walking the jury through his actual memory of arriving at the active crime scene back on September the 7th, 1996, when Tupac was shot, he did the exact opposite and burned Keefe D ass on the stand yesterday. He accidentally proved that Keefe D was telling the truth about a highly specific detail. In his past statements, Keefe D didn't just talk about shooting at Suge Knight's BMW. He mentioned a chaotic detail that only someone who was physically there or intimately familiar with the immediate aftermath would know. And that is that a car full of girls right next to them also got shot at that night. So when Detective Long took the stand and he testified that traffic was fully backed up on Las Vegas Strip and people were frantically waving his unmarked police car down, he looked and explicitly told the jury that when he pulled up to the scene, there was a vehicle of interest where some girls had been shot at. This destroyed Keefe D's defense. And it did that because Keefe D's defense had been trying to argue that Keefe D was just repeating widely known public rumors. However, that random, chaotic detail of a separate vehicle containing women being shot at wasn't a massive, widely publicized piece of Tupac information over those last 30 years. And by having a veteran homicide detective confirm on that stand, y'all, that this specific vehicle indeed existed and that women indeed were shot at in that exact same intersection, the defense inadvertently, accidentally, gave the jury hard, physical corroboration. It proved that Keefe D's inside knowledge of how all hell broke loose that night matched the exact reality of what happened on that ground. And what that did for the jury, it showed that this dude was an honest cop. The jury usually can tell when the witness has an agenda. But because Detective Dan Long, because he was called by Keefe D's team and was willing to openly admit embarrassing parts about the police investigation, like that unauthorized California proffer agreement and the stand-down order, he gained massive credibility with that jury yesterday. And with an honest, highly credible veteran homicide cop that looked at the jury yesterday and said, and I quote, "I had plenty of probable cause to arrest Keefe D for the murder of Tupac Shakur in 2009 that carried immense weight." Keefe D's own witness fucked him in the end. And Keefe D's entire case relied on the idea that he was just a liar and a storyteller who made everything up for entertainment, but Detective Long confirmed highly specific details, like those girls getting shot up in that crossfire. And he proved to the jury that Keefe D wasn't just telling some fairy tale fantasy shit, but he was basically describing a real chaotic crime scene that only someone involved would know about so intimately. And directly following Keefe D's own witness, Detective Long's explosive testimony, Keefe D did one last fuckery that destroyed him and destroyed his case. He officially waived his right to testify. So, the last words and testimony that the jury will hear is Detective Dan Long saying, "I had enough to arrest Keefe D for the murder of Tupac Shakur in 2009." And that was Keefe D's own witness. So basically, Keefe D's proffer was fake, and there's nothing he can do about it because that was in California. Keefe D's being tried for murder of Tupac Shakur in Las Vegas. And the Las Vegas Police Department had enough evidence, along with Keefe D's testimony, to convict him, or excuse me, to arrest him and charge him with the murder of Tupac Shakur. And for shits and giggles, for all of you doubters who are just still on the doubt train, well, I do you one better. This is what he said about those girls that night and those girls who got shot at.
A little bit about the activity that was going on at the time in terms of the streets and people walking around when you heard the shots being fired.
It was packed. It was extremely, there was people everywhere, people walking, traffic was fully backed up. We had to get into the intersection, we had to use, we were in non-marked cars, so we were in plain cars. We moved into the intersection using red lights and sirens. We moved across, people were waving at us and pointing. There was a vehicle there that became of interest to us. Some girls had been shot at. Some girls had been shot at. Some girls had been shot at. Of interest to us. Some girls had been shot at.
He's toast. He's toast. So while they had the first girl go up there and say, "Nah, we wasn't shot at. We wasn't shot at," Keefe thought he was walking out that thing pretty. Because the girl said, "Nah, we wasn't shot at." But the police officer got to the scene and saw a whole different group of girls in their car had been shot at. And that was Keefe D's own witness who admitted that on the stand, who was there that night. That was a key detail that only Keefe D gave to authorities. Nobody else talked about that in the whole Tupac situation. Nobody. It was Keefe D who gave that information to authorities. Think about it. Nobody else talked about that, ever, about those girls' cars getting shot up. It was dumbass Keefe D. How would Keefe D know that some girls' cars got shot up that night to tell the cops the exact details unless he was there or linked to who he was there or who was there? That boy fucked up real bad. And the cop that he called as his own witness buried his ass and walked right into court and said, "When I pulled up that night, man, after those shots went off, I pulled up with my other guy in an unmarked car, and we saw this girl's cars that was shot at right there at the scene." There was two different scenes. Remember, y'all, there was the scene that Suge Knight was found at, where the tires were blown out. That was down on the other street when Suge bucked a U-turn and went down there. That was bicycle cops. That was bicycle cops. And there was another scene where the actual shooting happened right there at that stoplight. And the cops said that they found the shell casings outside too, right there. And that girl's car was shot up. This is Keefe D's own witness. Buried his ass. Body bag. Casket. His own witness. His own witness confirmed that he didn't hear this, y'all. This isn't something that he's saying I heard through the grapevine. The officer said, no, I was there. And I pulled up on that scene when I heard the shots. Listen.
A little bit about the activity that was going on at the time in terms of the streets and people walking around when you heard the shots being fired.
Oh, it was packed. It was extremely. There was people everywhere. People walking. Traffic was fully backed up. We had to get into the intersection. We had to use. We were in unmarked cars, so we were in plain cars. We moved into the intersection using red lights and sirens. We moved across. People were waving at us and pointing. There was a vehicle there that became of interest to us. Some girls had been shot at. While we had gotten out to talk a little bit about the.
Some girls had been shot at. Boy, imagine Keefe D face today after they give these jury instructions. And I'm going to show you guys. I'm going to show y'all. Because I want y'all to see this man's face. I want y'all to see this man's face. He was so ashamed to expose dirty tactics by other police officers. But this guy, he was not corrupt. He was not a corrupt police officer. He actually was trying to do the work, man. That's crazy, bro. If the police did what they were supposed to do, Keefe D would have been arrested decades ago. But since the police didn't do what they were supposed to do, Keefe D was free this entire time. Ain't that sad? If you're Tupac's family, ain't that sad that this man was free this entire time? Think about that. Is that not sad? Press 1 in the comment section if you think it's sad that they went all these decades without arresting that man. Press 1. I want y'all to press 1. If you think it's sad that they went all these decades without arresting Keefe D, sad. They could have arrested Keefe D decades ago. But because the cops in California did that bullshit and then would not respond to them, the case sat in a locked file for all these years. And this is the reason why Greg Kading, this is the reason why Greg Kading has not been called in this case. Because they feel like he was ashamed to this case. It's sad. It's extremely sad. Extremely sad, man. And I'm extremely saddened. Because it is sad. It's very sad. I'm sad about what happened. And I think everybody else should be sad about what happened. I think everybody in this chat room should be angry. Because why did the family of Tupac Shakur have to wait all these years for justice? Keefe supposed to be locked down all these years. He's supposed to be in prison all these years. But since we're going to do it, let's get into it.
Can you describe for us a little bit about the activity that was going on at the time in terms of the streets and people walking around when you heard the shots being fired?
It was packed. It was extremely, there was people everywhere, people walking, traffic was fully backed up. We had to get into the intersection, we had to use, we were in non-marked cars. So we were in plain cars. We moved into the intersection using red lights and sirens. We moved across, people were waving at us and pointing. There was a vehicle there that became of interest to us. Some girls had been shot at. While we had gotten out to talk to them and find out what was going on, we had no idea this was attached to anything. One of the guys on my team, Dino Kelly, found some cartridge cases in the street. So we started moving our vehicles in the area to block off traffic so they wouldn't get run over, and putting up yellow tape.
Now, once again, were you in charge of the investigation of either the shooting or the eventual homicide?
No.
All right. So at the time in 2000 or 1996, you were anything other than your gang unit detective.
Right. And at that time, we had found a shooting scene. We don't know what we have. So we're just securing the scene in case there are victims. And then we would find out what was going on.
At some point in the future, though, as you progress in your career, did you ever at any point leave the gang unit?
Yes.
And what did you do after that?
In 2000, I was invited to test to go into homicide. I then tested for homicide and went into homicide.
And what year was that?
2000.
Now, during the time that you were in homicide, that would have been from 2000 to roughly when?
I retired from the department in 2017.
So you spent 17 years in homicide?
Yes, sir.
Okay. Now, during the time period that you were in homicide,
Somebody said that he was happy he was going to get off. He was happy in court yesterday. Yeah, because he's a damn fool to not process what happened to him yesterday. He's so damn stupid. He don't know that his own goddamn witness annihilated him. It doesn't make any sense whatsoever. You can't be this stupid.
were you ever assigned the case involving the Tupac murder?
Yes.
You had to stay a little bit. I just want to make sure. You were given the assignment at some point.
Yes, I was. 2004, my sergeant, Kevin Manning, handed me the file and said I would follow up any further leads.
All right. And can you explain to us a little bit about how that works? You're a detective. The file had been with somebody else prior, Detective Becker.
Yeah, Detective Becker.
Duane, great question. Great question, Duane. And I'm going to tell you how they're going to play it. You said the only thing I'm confused about is, did he die because he put his hands on Orlando, or did he die because of $1 million payout, paid hit? Well, the reason why they kept Kirk Burroughs and all these other guys out of this case is because they didn't want to confuse the jury for this murder right here. They put Diddy's name in this thing, but they didn't go as far as they could have gone. And the reason why they stopped is because they don't want to confuse the jury. So what they did is basically they're going to push it like this. Right now, they're showing you guys, okay, look, there was different aspects to this situation. They're going to say, hey, Diddy put a bounty on those guys' heads. And when that situation in Las Vegas happened, that beef popped off between those two gangs, they're going to say that's when they decided to cash in on that bounty that Diddy had put on their heads. This is the reason why they linked Zip to the whole situation, saying Zip said, hey, y'all need the blicky, right? Because they used Zip as being the middleman. And this is the reason why they had Zip giving Keefe D the gun and all this other stuff. Boom. So this is the reason why they're doing that the way they're doing it. They're doing that the way they're doing it because they don't want to confuse this jury. All they want to do is get Keefe D found of murder with a gang enhancement, and they're going to put Keefe D in prison for the rest of his life. And Keefe D is going to be fucked because he's going to be known as what they call an informant. So they know that Keefe D is going to even more want to talk to get out of this situation, right? So they're going to use that to roll Keefe D into Diddy and say, hey, man, Diddy did do all this stuff as far as with the payment. Then that's when everybody else is going to come in. That's why they shut them down in this trial, meaning Kirk Burroughs and those guys, because they don't want to confuse this jury. They're saying, look, we just going to go ahead and get him on a conviction right now. And then when we go get Diddy for that RICO murder for hire, that's when we're going to pack that nigga up. That's what's going to happen. Right? So really, they're going to use it as Diddy ordered the hit. They saw it as a time that, oh, shit, that nigga got a balance. Oh, we cash this shit out right now. Boom. That's how they kill two birds with one stone. That's what they're going to do. I'm telling you exactly what they're going to do. They have to get Keefe D convicted for murder first. Once they get him convicted for murder, then the Diddy part is coming next. Guaranteed.
Becker and Detective Mike Franks.
And now you have the file. So
Yes.
what do you do as a detective when you're handed a file that's already been worked on?
If they don't convict Keefe D, they don't get Diddy. Simple as that.
Becker and Detective Mike Franks.
And now you have the file.
Yes.
So what do you do as a detective when you're handed a file that's already been worked on?
You read it. You read it. I went through the pictures. I then discussed it with my sergeant. I went down to California. There was a lot in that file, and I didn't know Compton very well. I didn't know Compton at all. So I went down. I had ridden in the gang unit with gang detectives, and I knew them still. So I called and said, can you take me around and show me these things?
Listen, y'all, you have to listen to what this guy's saying. The reason why Detective Dan Long is so hurt, he had to throw his own officers under the bus. The worst thing you can do as a police officer is throw your own fellow officers under the bus. But Dan Long was such a good officer, he got on the stand and exposed the corruption in the police department with his own officers. You know how hard that is to do? And people just went past everybody's head yesterday. It went past the whole fucking media's head yesterday. Y'all hear it here first, and then everybody else can tell y'all about it later on. It went past all their heads what he did. He literally, in this segment, destroyed. And I'm going to tell you something. When you're a cop, to go against your fellow cops, that's like the lowest thing you can do. But he's telling the truth. So when it comes to Tupac's murder and his family, this is about justice. Listen to what he said. This is Tupac. I mean, this is the witness for Keefe D. Keefe D's lawyer made a bad mistake, bro. He should have never brought this guy up there, man.
So we drove around Compton. They showed me houses where the Compton Crips lived. They showed me where Orlando Anderson died. They showed me a lot of different things. And Compton was very small, but it was very impacted with gangs.
Now, during this time period, can you describe for us a little bit about was there still an interest in the murder of Tupac at the time that you took over the case?
I'm going to give y'all a secret. I'm going to tell y'all what I think they're trying to do. And this is just me being honest. I think they're going to try to go for the trifecta, which just means I think they're going to try to get Keefe D locked up. And then I think they're going to try to solve, because they only would have 50% solved the Tupac murder, right? According to what they feel. They're going to try to solve the Tupac murder with Diddy, and then they're going to try to solve the Biggie murder. What have they always said? You solve one, you solve both. That's what I believe the investigators are going to try to do. They're going to try to pack that shit up in a line, straight like that. They're going to try to roll Keefe D. They're definitely going to roll him into Diddy. And then they're going to double back and then try to solve the Biggie Smalls murder. They're going to use that as information. They're going to use all this to roll other people up into trying to get that Biggie case, Smalls case solved too. I'm telling y'all what they're going to try and do. Let's keep going.
Was there media attention? Maybe not to the level it was in the beginning, but was there still issues with regards to access to the file and everything.
Yes, there was.
And
Now I know where you're going.
yeah, and what I mean by that initially is that even in Metro, was there any concerns on your part about unauthorized access to the file?
Not by me. I wasn't concerned, but my lieutenant had become concerned and wanted to sequester the file away from everybody else because there was a lot of people going in and looking. Very, very famous person.
And with regards to the going in and looking, can you describe to the jury what type of activity we're talking about here in terms of going in and looking?
I didn't do any investigation in this, but my lieutenant told me that people had been going in and being curious, looking at the file.
Did you at any point, was there any measures that was taken to preserve the safety and security of that file?
Yes.
What were those measures?
They locked down the file itself, which was this, the hard copy of the file. We used to, at that time, we were on a computer drive called the F drive, which turned out to be too small. And they later moved it to another drive because homicide just kept growing. So they changed the way I did my reports. I would hand them in and they were secure.
Okay. Now, we talk a little bit about reports. What reports are we talking about here?
The one that popped into my mind, the very first one, there was supposedly this was an anonymous tip that there was a rolling 60 apartment over on Reno that was slinging drugs, and that the people that shot Tupac had driven up to this apartment and handed the gun off for drugs. I then attempted to locate, usually gangs are going to rent an apartment, they're going to rent it in a girl's name. So I was looking, and I'm talking 8 years after the fact. I'm talking about trying to find an apartment rented by a girl that has association with the Rolling 60s. I never found it. So I couldn't track down the 60s that may have the gun that would be attached to the killing of Tupac.
I see. And during the time that you were performing your duties as the detective on this particular file, did you ever keep your own officer's reports?
Yes.
And just explain for us a little bit about your, common course of how you would do that.
An officer's report is like who, what, when, where, why. So you say that there was an anonymous tip. Let's just talk about this tip. Anonymous tip at this date. I did these phone calls, met with this apartment complex, and couldn't locate anybody that was attached to the Rolling 60s in any fashion. So it literally would be an officer's report that's maybe a paragraph. There was another tip that the gun had been dropped from the shooting vehicle that went back to California that night, and it was on the side of the road. Ridiculous. But 8 years later, we went out, we walked that section of the freeway, both sides, looking for a gun. We didn't find one. That officer's report was about a sentence. And those kind of things, those kind of things are the things that we were trying to run down.
All right. And so in terms of officer reports, fair to say that there would be a lot of officer reports of your efforts in this particular investigation.
Those officers' reports don't exist anymore that I could find.
Okay. And why is that?
From what I was told was when we moved from the F drive to the H drive, those reports had to be scanned, and at some process they were lost.
So what we're relying on, clearly, it would be your recollection of what you remember from that time period.
Correct.
Okay. And once again, if you don't remember, you don't remember.
Okay.
Okay. Now, at some point, though, you have an opportunity to interact with law enforcement officers in Compton. Or is it, no, I'm sorry, at that particular point, it would have been the Sheriff's Department, LA Sheriff's.
Yes, I usually went directly to LAPD, but yes, the Sheriff's Office also.
LAPD. Can you tell us a little bit about any interaction you might have had with them, specifically about a firearm?
You're talking about the 06
Yes.
Yeah. I received a phone call from the Los Angeles Sheriff's Department saying that there was a gun recovered by Compton PD in 1998. The yard of 1301 Sloan, which is inside the Compton area, the Compton Crips area, I should say. And they believe that this gun was supposedly buried in the backyard, and it was turned over to the Compton Police Department. The Compton Police Department dissolved, and so the Sheriff's Department was starting to run all these guns through ATF and ballistics, and they believe this may be the gun that we were looking for. They were fairly adamant that this was the gun that we were looking for, that was the murder weapon of Tupac. I then made a drive to LA with my sergeant. We picked up the gun. They had it in a evidence box. I signed a receipt to them that they kept. I then drove the gun back to Las Vegas, drove it directly to our ballistics lab, and I turned the gun over to Jim Krylo. I then filled out a request to have that ballistics tested against the gun that was used to kill Tupac. Before I managed to drive back to the office, I received a phone call and they told me it was not the gun. I told him that he wanted me to come back and pound it and put it into our evidence vault. I told him I'd come back in the morning and I would pick up the gun and I would take it back to LA because it may be of interest to LA in another crime.
Okay. And outside of that particular incident, were there any other instances where you found what potentially could be the gun in this situation and had it tested?
Myself, no, but there were thousands of guns that were tested.
And as far as you know, as the responsible detective at that time, were any of those thousands of guns come back with a hit or match to the spent cartridge cases that we found in the scene?
No.
Now, in addition to that, at some point in the future, you travel to California again to conduct an interview.
Yes, sir.
That would have been in 2009.
Correct.
Okay. Can you tell us a little bit about who was there in that interview?
Sure. Myself and my lieutenant, Lou Roberts, made a drive after I received a phone call saying that there's somebody that wanted to give information about Tupac and Tupac's murder. We then drove down on the morning of September 9th. They wanted us to meet them at the HIDA office, which is at 1340 West 6th Street in LA, which is about 6 blocks from Plaza One. We met them there. I would then met Detective Darren Dupree, and he told me that Duane Davis, also known as Keefe, was in the interview room. He had his attorney present, whose name was Wayne Higgins, and we were going to go in and he was going to give me information. And he further explained that Keefe had got caught with a large amount of narcotics and was trying to work off those charges.
Now, sir, and just to cut you off with that part, I apologize. But with regards to that information, it's
Now, he cut him off because of what he was going to say to the defense, which is that he wasn't supposed to be able to do that. Keefe's lawyer caught that and was like, no, that's all I want you to say right there. He tried to be slick. And it's going to backfire on his ass. It's definitely going to backfire on his ass. He tried to be slick about that shit. It's going to backfire that he tried to be slick. It's going to backfire bad, right? Now, let's get into this, you guys. And let's be honest about this, right? Let's go.
at some point you conduct an interview in that room.
Yes, sir.
With Mr. Davis.
With Mr. Davis, with his attorney. My lieutenant didn't want to go in, so Darren Dupree agreed to go with me.
All right. And there was a recording. Did you record the meeting?
I did.
Okay. And is that just standard operating procedure for what you do as a detective?
Yes, I was told that they were going to record it also. but I wanted to record it myself. That way I have it in my hands.
Okay. And during the course of that meeting, you learned information, right?
Yes, sir.
Now, can you tell us a little bit about the interaction here? Were you ever asked to leave the room?
Yes, sir.
Can you tell us why you were asked to leave the room?
Mr. Davis became very nervous. I was asking questions that he didn't feel comfortable with, which is to be expected. And he asked me to leave the room. He wanted to talk to his attorney and he wanted to talk to Detective Dupree. I then stepped out of the room for not very long, and then they asked me to come back in.
Was there ever a time that you left the room and was accompanied by Mr. Dupree and only had Mr. Higgins and Mr. Davis in the room by themselves?
I don't recall that.
So every time you left, Mr. Dupree was in the room with Mr. Higgins and Mr. Davis.
Yes, sir.
Now, at some point, you were able to learn some information.
From Mr. Davis?
Yes.
Yes, sir.
When you came back, did you corroborate any of the information?
I tried.
Okay, and what did you do? What efforts did you make?
During the interview, Mr. Davis indicated first that Orlando Anderson, or Baby Lane, had been beat up at the MGM, which we all had video of. I think everybody on the planet has seen this video. He was complaining that his arm was either broken or out of socket. He first told me that they had gone back to California and had gone to the hospital in California. But he said they went to the hospital on Maryland Parkway, and the hospital on Maryland Parkway is Sunrise, and that he had gotten a sling for his arm. So I filled out a subpoena, and I wanted to know if Orlando...
Think about this. How the hell do Keefe know it's a hospital on Maryland Parkway? Keefe D didn't live in Vegas. Keefe D lived in California. How could Keefe D tell him at that time, yo, we went to the hospital on blah, 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 if he didn't live there? He lived in California. Keefe D lived in Compton, California. The only reason why he came to Vegas was for the fight. Boy, that dude's cooked.
Orlando had signed in, was examined in any fashion. And now we're talking, this is 2009. We're talking about somebody coming into the emergency room in 1996. So I didn't find anything. They couldn't apply. They couldn't give me anything with Orlando's name on it.
Keefe D feeling good right now. He's like, yeah, see, y'all ain't got nothing. Boy, when the daggone cross-examination happened, Keefe D got destroyed.
We were looking into, there was a rented Cadillac, rented in Compton by a friend of the gang. Her name was, or her daughter's name, there was a woman by the name of Harris. And first name could have been Teresa, could have been Tessa. And again, we're talking multiple years later. But I called down trying to locate a Cadillac that was rented in 1996. They said it was a friend of the gang. So it's very possible that there was no paperwork on it. But we're going to try. I called multiple rent-a-car places because he couldn't remember which rent-a-car place it was. I never found anything connected to that date or those dates around that for a four-door white Cadillac of any kind.
Now, in addition to that, sir, did you ever run at some point any names to determine, sort of help you out with the landscape of who's who and what's what? For instance, did you ever run a name by the name of Darnell Grimm?
Oh, you're talking about before the interview?
Yes.
When I received the call that we were going to go down and do an interview, I ran everybody that was in the file. And the purpose of that being is if I'm in the middle of an interview and he mentions somebody, I might have information, this person's in jail, this person's dead, this person's in prison, those could be very useful to me in the middle of an interview. When I go into the interview, I'm going to be acting very non-informed. I don't know anything. Please tell me. So he's like, okay, we were going after, we're talking about Pac. Okay, who's Pac? Well, Tupac Shakur. Okay, so I'm going to do that through the entire interview. But if I have more names and more information, I at least know what he's talking about, so I can direct him in the right direction to give me a full name or a full description, whatever it may be. So I ran quite a few people before I went down there.
Okay. So at some point you leave that interview and you come back to Las Vegas.
Yes, sir.
Were you ever aware that in 2008, Mr. Davis gave a proffer to the FBI, DEA, Compton PD, LAPD?
While I was there,
Yes.
no. I was told that he had been, Duane Davis was arrested on a major drug case, and he was facing the rest of his life in prison. And he was trying to work that case off. So when I was sitting out there and I learned that he's sitting there with his attorney, I'm like, he's not going to tell me anything. And they're like, well, he's trying to work this off, and it's about Tupac. And I'm like, all right, let's try this. So we went in, but we finished, we made a drive over to Plaza One, then we left. I received some phone calls at that point and received more information when we got back to Vegas that there could be possibly a proffer, which made no sense to me.
Now, just one final question for you, and it's unrelated to anything that we've asked so far.
Sure.
The question is this: are you aware of a program here in town called Barry's Boxing?
I've heard of it.
Okay. I have no further questions, John.
Now watch how you get cooked.
Pass, Mr. DeJohnson.
Watch how you get cooked, y'all.
Detective, how are you?
Good. How are you, Mark?
Good friend.
Jack.
He's toast. You see how the motherfucking prosecution walked up? Hey, what's up, buddy? Game over, motherfucker. You got to peep all this little shit happen during the trial, y'all. Y'all smash the like button, y'all in the chat. You have to peep this little stuff. Bro, he got cooked, bro. This motherfucker Keefe D sitting over there thinking he gonna walk out that bitch clean. Look how they got he greet him. Hey, what's up, baby? You already know we gonna pack this motherfucker up. See, this is the type of shit y'all don't notice that I be showing these cats, cooking these motherfuckers every single day. He said this here Keefe D lawyer came up here and brought you up on the stand. Man, this is why I told y'all he gonna get cooked. Nigga, this your own witness, nigga. Now let's watch this play. Look how he's smiling, y'all. That motherfucker smiling like a kid on Christmas Day.
Okay. I have no further questions.
Look at him when he come up, y'all. A kid on Christmas Day. Look at him.
Detective, how are you?
Good. How are you, Mark? I'm Mr. Jack.
You went to homicide in 2000, correct?
That's correct.
And Mike Franks and Brent Becker. Well, I guess Mike probably retired before Brent left the unit, correct?
Well, he trained me for a while. Mike was preparing to retire, so the desk I was going to get was his. And I was trying to soak up as much as I could from him because he was a very, very senior detective. Him and Brent Becker were very, very good detectives. So.
See? Hey, this motherfucker lying Keefe D up. So he first comes in there and says, hey, man, you know, I was just coming over to homicide, but I was taught by some very good detectives, man. They were some good guys. Brent Becker and the other guy, they were good guys, man. They did good work. They were good guys. Why is that important? That's important because Keefe D, dumbass lawyer, didn't know. This lawyer came on the case 13 years late. The other officers had already been on the case and did all the prior investigations. So he had all the information that his prior good officers had already done. Game over, motherfucker. So when Keefe D's lawyer says, oh, you didn't see anything? No. I didn't see anything. I was there 13 years late. But these guys did. It's all in the file.
Detectives, so I was trying to suck up as much as I could.
Listen to it, y'all.
I was going to get was his. And I was trying to soak up as much as I could from him because he was a very, very senior detective. Him and Brent Becker were very, very good detectives.
Very good
so I was
detectives.
trying to suck up as much as I could.
Listen,
That was the squad I was going to anyway.
And when Sergeant Manning hands you the Tupac file, you
got
already
handed a
had
Tupac
an
file.
understanding from Mike Franks and Brent Becker of who you thought was in the car.
Yes, sir.
now, listen, y'all. He already had the 2 senior officers. They were getting ready to leave out. He was coming in. Those senior officers already had all the information and evidence against Keefe D. They handed him the Tupac file. They handed him the Tupac file. They already knew who was in the fucking car. They already knew who was in that car. Listen once again. Listen once. Keefe D's own lawyer called this witness up. This witness buried his ass. Listen, y'all.
And when Mr.
I was going to get was his. And I was trying to soak up as much as I could from him because he was a very, very senior detective. Him and Brent Becker were very, very good detectives. So I was trying to suck up as much as I could. That was the squad I was going to anyway.
And when Sergeant Manning hands you the Tupac file, you already had an understanding from Mike Franks and Brent Becker of who you thought was in the car.
Yes, sir.
And when Mr. Davis in 2009 tells you that, it's the same people.
Yes, sir.
It's the same people Keefe D told
I
me.
think
They already had.
Mr. Samft maybe missed one of your trips to Compton prior to, I guess, November of 2004 when he died. In early 2004, did you try and make contact with Big Dre Smith?
Yes.
And describe that for us.
I was with actually a gang squad, and this is during the time when you can read it all.
Why did he say that? Because Keefe D's lawyer tried to make it seem like, they wasn't investigating these guys. It's bullshit. Guess what? His own witness on the stand says, no, I tried to go fucking talk to Dre Smith, and he told me to fuck off, which goes right against what Keefe D's defense is saying that, they didn't try and do any of these things because they didn't think this was real. Yes, they did, motherfucker. And he walked right up to Big Dre, and Big Dre told him to fuck off. Listen, it's right here.
You can read all this information, but it's better if you go down there and look at it. So I went down to look at it. And they were taking me on a tour, most of Compton. They took me to the car wash where Orlando died, that kind of thing. While we were driving by the Emerson Elementary School, which is right in the center of the Compton Creek turf. Some of the guys I was driving in the back seat and taking notes. They said, there goes Big Dre, DeAndre Smith, which is somebody that's obviously in Brent Becker's files. And he was walking through.
He's in the files. He's already telling you that Big Dre is in those files. Are y'all not hearing this shit? I don't think that's why I be telling y'all people are stupid on YouTube. They don't understand what the hell they be listening to. Let's keep going. And to the dude who says, why didn't they charge at least one? You idiot. Listen to what we telling you. We're telling you this again, brother. Hold on. To the brother who said it in the comment section. That's a great question. Hold on. No. To this brother right here. Hold on. My bad. Where that brother at? If they knew who was in the car, why didn't they charge at least one on with the murder? Sir. The police department didn't charge him with the murder because Keefe D gave a proffer. The LA cops are playing dirty. Do you not understand now? If Keefe D was never given that fake ass proffer, game over. Shows you how dirty the cops were, bro. And the cops, they can charge you when and where they want to charge you, bro. It shows you that they sit on shit for whenever they want to release it, bro. It's sad, bro. Let's keep going.
The field, the grass field.
So I was like, well, stop. Let me talk to him. You got to try. You know, I have no probable cause. I have no legal right.
So the person said the much bigger question is why now? Because remember, there was a legal situation that was going on because the LA office would not return the calls to Las Vegas. So Las Vegas didn't know whether or not Keefe D's agreement was, for all those years, they didn't know whether his agreement was signed off by the U.S. District Attorney. So they didn't want to take a risk of charging Keefe D, and he already had a cross-state proffer agreement that would have destroyed their case. And because the L.A. department would not return their calls, the case sat on files for years for no fucking reason. Because they gave him a fucked up proffer because they wanted to resolve the situation with Biggie Smalls. That's what they were worried about. Resolving the case from Biggie Smalls. That's why. So now the reason is because when Keefe D came out talking shit in interviews, none of that shit mattered. They didn't have to wait on the LA cops no more. Once he came out and did it on interviews, even if he had an ironclad proffer, the fact that he came out speaking out on interviews, it fucked over his whole situation. And it gave Las Vegas the loophole they needed to go get that motherfucker. Period.
Legal right to make a stop. I'm not even in my jurisdiction, but I can try. So I stepped out of the car and I said, Mr. Smith, I'm Detective Long from Las Vegas. And he said, F you and F off. He's not censoring what he said. And he just lumbers across the field. So I had no reason to stop him. So I just waited.
Now, in 2009, you wind up in a room with Mr. Davis, and your belief is he's trying to work off charges. What does that mean?
He's looking at the rest of his life in prison for what they had caught him with. So if he gives substantial information about cases, and that's what they had brought him in for, was to give information about cases. One of the cases was the Wallace case, Notorious B.I.G. During this part of it, he started telling them about Tupac, and this is in 2008, I believe.
Right? So think about this, y'all. California didn't give a fuck about the Tupac shit because they cared about the Biggie Small shit. Why? Because Biggie's mom filed that $400 million wrongful death lawsuit. So the whole reason why they dug all this shit back up and redid that task force with Greg Kading was because of Biggie Small's mom's lawsuit. So they had already thought Keefe D was involved in Biggie's murder. That's the only reason why they ran down on Keefe D as far as that proffer. Not for Tupac. When he gave them Tupac, that was icing on the cake. But because they gave him a fake proffer and didn't want nobody else to know, they didn't notify Las Vegas because they didn't want to have a clusterfuck and look bad for not going through the proper channels of giving Keefe D that proffer. So it exposed the bullshit going on with LA cops.
That's what I was told.
But essentially, and I want to talk about specifically, what is just working off your charges? Does Metro have certain rules? Let me ask you.
He's going to tell you they broke the rules. Listen.
Working off charges and how you work off charges.
Yes. And a non-victim crime, you can work off charges. You can't work off a murder. You can't work off a sexual assault. You can't work. Those are victim crimes. If you have a victim, you can't work off those charges. But if you have something else that, like a lot of drugs, you can work off maybe the amount of years you're going to do by giving substantial case information on other cases. So that's what I believe.
Right. So what they did was, y'all, they broke the rules. The cops. What they did was they broke the rules. The reason why they broke the rules is because they needed the evidence in the Biggie Small situation and the information. So when Keefe D gave them the information they needed, that it was a gang war that popped off with the Crips and the Bloods, and it was a gang war that had popped off behind the record labels, Bad Boy and Death Row, that gave them what they needed to get out of that Biggie Smalls wrongful death lawsuit from Violetta Wallace. That's why they didn't want to fuck with Keefe D. They was like, we won't give a fuck what y'all got on Keefe D. He helped us get off that goddamn $400 million lawsuit. That's why. Use your brains. So they fucked over Las Vegas in the process. And Las Vegas already wanted to charge Keefe D, but couldn't. But when Keefe D started running his mouth, now it doesn't matter what California said, because Keefe D violated any agreement he could have by coming out talking about it publicly. And that's why they went without even talking to California. Boom, they went and charged Keefe D immediately when they could. Get it now?
Mr. Davis and his attorney were trying to do was to knock off a certain amount of time off of what he was going to spend in prison.
And you know, or at least you believe, you'd agree with me, that Mr. Davis was a suspect in your homicide, not a witness.
Suspect.
Yes, sir.
And by the end of that interview, what is your intent?
My intent was to drive back to Las Vegas, type up a warrant for an arrest.
He was going to go back to Las Vegas. Peep game now, y'all. He was going to go back to Las Vegas. So this is a Las Vegas cop that went all the way to California. Are y'all understanding now what happened? The Las Vegas police already had enough evidence to arrest Keefe D. They already had the evidence they needed. The confession just did it. But when they found out that there was a proffer, that fucked them up big time. Because they didn't know if they was legally able to go after a proffer, because it was a state line proffer. But when they found out in the aftermath that the proffer was bullshit, that's why he exposed this in court yesterday. Listen.
Arrest, clear it with the district attorney, and have Mr. Day back to Las Vegas.
Listen.
Or at least you.
He buried Keefe D right here. This nigga looked right at the jury and told the jury, I was going to arrest that motherfucker for murder. Listen.
Or at least you believe, you'd agree with me.
Look how he looked at the jury.
Mr. Davis was a suspect in your homicide, not a witness.
Yes, sir.
And by the end of that interview, what is your intent?
My intent was to drive back to Las Vegas, type up a warrant for an arrest, clear it with the district attorney, and have Mr. Davis arrested for murder.
Now, at that point, did you and members of my team have an opportunity to actually listen to the recording?
Yes, sir.
And we heard the section where you're not in the room, correct?
That's correct.
And then, so did we give you some direction?
Yes. So this is
No, you're not listening, man. I don't think you understand what I'm saying. I'm glad you asked that question, because people are asking questions. I'm going to explain it to you, Karen. Salute to you, baby. No. Yes, they wanted to close the case with Pac. They wanted to solve the case. But when they found out that Keefe D could have potentially had a proffer agreement, they didn't want to risk it, because if they would have charged Keefe D then, and Keefe D had a legitimate state by state proffer agreement that was signed off by the U.S. District Attorney, they would have fucked their whole case. The whole case would have been fucked. So when they called California to find out, hey man, what's going on? Like, what's up? They was calling the district attorney and shit. Nobody returned their calls. You know why they didn't return their calls? Because they didn't give a fuck. You know why they didn't give a fuck? Because they only cared about getting rid of that Biggie Smalls wrongful death lawsuit, and the information Keefe D gave them helped them do that. So everything else they ain't care about. Tupac didn't happen in California. Tupac happened in Las Vegas. So it goes to show you that the two police departments were not locked in. That's why this guy says, hey man, when I went to go get the arrest warrant, my superior told me to stand down, because they couldn't get in contact with California. So you can't do this if we can't get in contact with California, because we don't know for sure how legitimate the proffer agreement is. So it just sat there for decades until Keefe D came out running his fucking mouth and he broke the proffer agreement, period, entirely. So if there was any proffer agreement that was legit, he broke it. Then in the aftermath of him breaking it, they found out that the proffer agreement was bullshit. That's why he's exposing all them dirty cops that did, or should I even say dirty cops, but all the cops who did a bad proffer agreement with Keefe D. Let's get to it.
This is several weeks after I come back. I met with. This is several weeks after I had come back from California with the recording. So we brought the recording and the transcription over. The DA reviewed it, and they invited me over, and they told me that they were not going to go forward with prosecution at that time because they're.
Look how you look.
Let me
It's a shame.
Let me ask you this way. Were you directed to find out the circumstances of why it was that a suspect in our homicide was in a room with his lawyer and a task force officer having that conversation?
Yes, sir.
And at this point, you've been told there might be a proffer somewhere out there in 2008.
Yes, sir. That's correct.
And proffers are between lawyers and sovereigns, correct?
That's correct.
So it's either got to be the U.S. Attorney's Office or the Los Angeles District Attorney's Office, but it certainly wasn't the state of Nevada or the Clark County District Attorney's Office.
That's correct.
And did you make efforts to find out from Wayne Higgins what the nature of that agreement was between him and some other sovereign?
Yes, Mr. Higgins as well as others. Yes,
And you would agree with me that Mr. Higgins wouldn't return our calls.
that's correct.
Did you attempt to contact U.S. Attorney Seawright?
Yes,
Didn't return his
And you
call.
would agree with me, Mr. U.S. Attorney Seawright, at least at that time, would not return our calls.
correct. Would not speak to me.
And by the time, well, let me ask you this. Based upon that situation, did you get directed to reach out to Darren Dupree to see if we could get leverage on the driver, Terrence Brown?
Yes, I did reach out to Detective Dupree and Clarence Brown is a gangster operating in Compton, California. So he's going to be committing crimes. I asked him if he gets arrested for whatever reason to give me a call, and I want to come down and talk to him. Yeah.
And ultimately, that never happens. You never get a phone call saying, hey, we got Bubble Up in custody. Come down here. Let's interview Bubble Up.
Correct. Bubble Up is the street name for Mr. Brown.
And so by the time you retire in 2017.
Oh, they tried to get the other guy too. They're showing y'all this in court. This is in testimony. This is why I keep trying to tell y'all. When they said they didn't do any investigation, they didn't try to, because they didn't take it serious. Yes, they did. They tried to go get these guys too. Couldn't get them.
17, we have no statement from Bubble Up.
No.
And we still don't know the circumstances surrounding why those three people were in a room talking to you.
No, I believed I did at that time, but obviously I didn't.
Thank you. Nothing further.
Now watch this.
Sir, can you tell us who from the district attorney's office you were speaking to during that time period?
Mostly it would be Pam Weckerly.
Who was the other United States or the district attorney as well besides Pam Merkley?
The entire MVU.
Was Mr. DeJochimo one of those individuals?
Yes, sir.
Now, at the time, who was the elected district attorney? Was it
Mr. Wilson.
Was it Steve Wilson?
Yes.
Now, not David Roger.
No, I don't believe he was there anymore.
All right. Now, your testimony here is that you had every intention when you came back to charge the case.
Yes, sir.
And when you came back, you reached out to the district attorney's office and you said, hey, we think we should charge this case.
Yes.
And they did not immediately give you a response as to what they were going to do.
No, they told me to stand down and they were going to review it. I got the information to them as quickly as I could. It had to be typed up by one of our secretaries, but I did make sure they got the audio as quick as they could. There was plenty of probable cause to arrest for murder.
Plenty.
Sure. Now,
Came over. He easted him. He told him there's plenty of probable cause to arrest that man for murder. Right there in front of the jury. So he's not telling y'all, oh, we ain't had no evidence. We ain't had no cause. Bro, you have to have probable. Before you arrest somebody, you have to have probable cause. Does everybody know what probable cause is in this chat room? Right? Do y'all know what that is? I'm asking y'all a question. Does everybody know what that is? If you don't know what it is, I'll explain to you real quick. Y'all understand? All right, so listen. If you don't know what probable cause is, I'll explain to you right now. Probable cause is the legal standard that requires police officers to have solid, common sense reason backed by facts. Let me repeat that again. Backed by facts. Not a hunch. Not I got a vibe. By facts. Let me put this on the screen for y'all. Because I know that's why I be trying to tell y'all niggas get cooked. They don't know what the fuck they talking about, man. Oh, they ain't got no evidence. Are you a dumb son of a bitch? Let me put this on the screen, man. Tired of cooking these niggas 3 the hard way. Every day I come in here, I just cook new niggas who ain't got no brains. Nigga don't even know what probable cause is. Let me put this on the screen. Let me make sure I put this up here for y'all. Hold on. Because niggas gonna learn that they gonna get the belt today, nigga. Do y'all see it on your screen? Let me blow this shit up, man. Can y'all read that? Probable cause is the legal standard that requires police officers to have a solid common sense reason backed by facts before they can arrest someone. Search property or get a warrant. Let me repeat that again. Probable cause is the legal standard that requires police officers to have a solid common sense reason backed by facts. Facts. Not innuendos. Facts. Before they can arrest someone, search property, or get a warrant. It means that the facts available would lead any reasonable person to believe a crime was committed and that the suspect is the one who did it. You understand now? It's all them lame ass niggas be arguing in the comment section, be getting cooked every day. To understand how it works in a police investigation, it helps to look at the rules of how it compares to other kinds of evidence and some everyday examples. The rules of probable cause. These are the rules of probable cause, y'all. It's no gut feelings in that. Meaning a police officer cannot arrest you based off a hunch or a vibe or simply because you look suspicious. Looking nervous is not a crime. The Fourth Amendment. This rule comes from the Fourth Amendment to the U.S. Constitution, which protects citizens from the government invading their privacy without a good, lawful reason. What does that mean, Ticket? You know what that means? That means that the cops cannot search your house right now without a warrant to search your house. What do the cops have to do to get a warrant to search your house? They have to have factual information, probable cause, signed up to a judge that by them searching your house, they will obtain what they're seeking to obtain, right? So let's say that the cops have gathered information that you're a drug dealer, right? And they have evidence of you dealing drugs. And they have proof that you deal drugs out of your house. Well, they take this to a judge. and tell the judge, hey, we want to get a warrant to search this house because there's drugs inside that house. And we have a factual reason to believe that when we search this house, we're going to find all these drugs in this house. And a judge has to sign off on that. So they'll go get the search warrant from a judge. A judge will sign off. And then that's how they search your house. Now let's keep going. The totality of circumstances. Judges and police look at the whole picture. They add up small pieces of evidence together to see if it makes a crime probable, which is very likely. Right? Right? Let's keep going. The staircase of proof. In the law, think of evidence like a staircase. You need to climb higher on the stairs to take bigger actions against someone. Right? Y'all understand this now? Okay. So step on the stairs. Number one, you have a suspicion. Right? What does that mean? It means you have a gut feeling, but you don't have any facts. What can the police do? They can talk to you, but you can also walk away. Let's keep going. Number two, reasonable suspicion. Specific, clear facts that a crime might be happening, right? Now, they can pull your car over or briefly pat you down for weapons, right? Number three, probable cause. A fair probability that you committed a crime, meaning they can arrest you, search your property, or get a warrant. And beyond reasonable doubt, overwhelming proof with no logic-based doubts left, a jury can convict you and send you to jail, right? So, the real world example, to see how an officer's evidence can grow from a guess into probable cause, you got to look at these scenarios. Example A, if you're driving, an officer pulls over the car because it's weaving across the lanes. So that's a reasonable suspicion to stop the car. When talking to the driver, if the officer smells alcohol, notices a slurred speech, and sees empty beer cans on the seat, the officer has probable cause to arrest the driver for drunk driving. Are you listening now? Do you understand now? I'm breaking this shit down elementary for y'all. Number two, example B, property. A store gets robbed. A witness says a man in a neon green hoodie ran out holding a crowbar. A few blocks away, a police find a man in a neon green hoodie holding a crowbar and a bag of cash. Because the physical evidence matches the witness story, they have probable cause to make an arrest. Right? Now, that's what probable cause is. So when he says, yo, we had probable cause back then, he already had enough to go arrest that motherfucker back then.
Probable cause is not beyond reasonable doubt. Fair.
Say that again. I'm sorry.
Probable cause is not beyond reasonable doubt, right?
No, that's what we do here.
That's correct. And in terms of the information that you had learned at the time that you met with Mr. Davis, did you verify any of that information?
Let's say it again. I'm sorry.
Did you verify any of the information in that recording in 2009 that Mr. Davis said?
I wasn't able to.
And once again, verification meaning corroboration.
Now, this is where
That's
niggas
correct.
stop listening. Right? He says, I couldn't verify any of the information. I couldn't corroborate it. But remember, he came 13 years late. They tried to cherry pick and they got checkmated. Watch this. Because as soon as he sits down, the prosecution gets up and says, hey, you weren't able to find it, but were your superiors? And he says, yes, checkmate.
That's correct.
In fact, I think on the recording you had told Mr. Davis a couple of times, look, even though what you're telling me you might say is the truth, I still need to corroborate this information.
That's correct.
And that would have been your standard operating procedure with anyone telling you anything.
That's correct.
So for instance, as you're sitting here right now, do you have any?
I'm going to object to leading. It's his witness.
I'm sorry, I'm so used
It's
to
hard,
it.
I know.
Let me ask it this way.
Better rephrase.
Yes, I'll rephrase. Did you make, was there any information did you ever receive about whether or not Mr. Davis was in Las Vegas in September of 1996?
Well, objection leading.
He can say yes or no. Overrule.
Did I?
And did you ever have, when you reviewed the file in this case, were there any people calling in saying that they did it. They did the murder.
Sure.
I mean, can you give us a number or an amount?
There was a lot. There was quite a few. I mean, I had information that Bill Clinton had him killed. I mean, there was no, he did not follow up. There was a lot of calls, a lot of people claiming to have been involved. No.
Yeah. And fair to say,
Most
though,
of the time they couldn't get any of the information correct.
right. And so when you're determining,
Listen what he said. He said most of the time they couldn't get the information correct, meaning we already had evidence. The people that was calling talking shit, they couldn't even get the information correct. Bro, these people don't comprehend. This is why I be getting so mad on my channel. Let's keep going.
for instance, a confession, what are you looking for? Like, if someone says, I confess to this, what information do you use to determine whether it's correct or not?
They're like, what kind of vehicle were you in? How did the shooting occur? What kind of firearm was it? Where did you go from there? What preceded it? How did you? All of it. I mean, anything that you can find as in facts, you want to connect to them. I'm behind the 8 ball because I'm 15 years after the fact or 14 years after the fact trying to corroborate different things. But I mean, I made the attempts.
And with regard to the information that we're talking about here, was any of the information you're sharing with us already available to the public?
I don't know. I'm sure there was information that's out there. I mean, there was so much interest in the case. I'm sure there was.
Now, just finally, in terms of your reaching out to people, Mr. Seawright, who was he?
The Attorney General of California.
And the district attorney's office requested that you reach out to the Attorney General of California?
They were going to do it. I was going to do it. Whoever could do it, which could be great.
And then in terms of the other people, Mr. Dupree or Detective Dupree, when was the first time you ever met Mr. Dupree or Detective Dupree? I apologize.
I'm not positive.
Was it in the meeting at 2009?
No, I met him before that.
Can you give us sort of an estimation as to when that was?
A couple of years before. I think it had to do with one of the gun trip. I think is when I met him.
And just for my edification with that gun, was it a real gun?
Yeah, Glock 40. There's a lot of Glock 40s out there. I had no idea there was that many.
Cooked.
Thank you. I have no further questions. Thank you, sir.
Real briefly. Well, Mr. Sam said, were you able to corroborate information that Mr. Davis gave you?
Checkmate.
You're talking about information you didn't already know, correct?
Correct.
There was a substantial amount of information in this file that Mr. Davis, Mr. Brown, Mr. Anderson, and Mr. Smith
Checkmate.
were in the car the night when the murder occurred.
Yes. The way I took when he asked me that is, did I do cooperation? Brent Becker and Mike Franks, the original detectives, corroborated a lot of different things.
Checkmate.
I didn't specifically go back in time and do what they did.
You were relying upon the information they already had. So when Mr. Davis is telling you this story, it's not like the crazies that are calling saying, I killed Tupac or Tupac's still alive or all any of that stuff.
That's correct.
Nothing.
Checkmate.
Any agree?
Easy work, man.
With
Easy
some-
work. Easy work, bro. Easy freaking work, bro. I'll be trying to tell y'all this, man. Easy work, man. Easy work, bro. Yeah, they packed them up so quick, man. I'm trying to tell y'all this shit, bro. Nigga don't be want to listen, man. Can't even tell you what day it is, nigga. Packed his ass up. Point blank period. So when you go look this up, you guys, when y'all go look this shit up and y'all doing y'all research, y'all doing y'all homework, make sure you look it up right. Make sure you look it up right. You have to do that, bro. That is very important. Hold on, y'all. They about to read the jury instructions. Hold on. Let's go over to that right now. Hold on. Hold on, y'all. They're about to read these jury instructions. Hold on. Let's see what's going on. Hold on, y'all. Let me blow this shit up. Hold on, you guys. It's going to get quiet for a second, y'all. Let's see what the jury instructions say. Hold on.
record. On record in State versus Davis, C-377-407. For the record, Mr. Davis has waived his appearance for this hearing previously. What document are we working off of, Mr. DiGiacomo?
The one I just sent you.
Okay.
We negotiated some language in a bunch of the instructions.
Okay.
The issue still before the court, and I sent, you got the defense instructions earlier.
Yes.
Is one, whether or not we give a voluntariness, and if we give a voluntariness of the statement, what voluntariness of the statement instruction should be given.
Okay.
Two, we have a dispute over what corpus delicti rule instruction we give.
Of course.
The defense has withdrawn their 51069 request. The attacking the hearsay as if he testified to the declarant, as if he testified, they've withdrawn that.
Okay.
And then the defense does not want self-defense instructions, but the state believes we're entitled to them since Mr. Davis claimed self-defense in at least one of his statements.
Good morning, Your Honor. Attorney Talene Panduck, bar number 5734 on behalf of the defense.
Okay.
I did print a copy of our initial defense proposed instructions. Would you like a printed copy for now?
Have an email copy if you want those filed. Go ahead and,
Well,
as
we
proposed.
are withdrawing one of the instructions
Okay.
on page 9. On page 6, we're withdrawing the hearsay instruction. Pages
Okay.
7, 8, and 9, the state has agreed to modify those and use our proposed exhibit.
Okay.
So you are here to determine if the defendant is guilty or not guilty based on the evidence in this case, as opposed to guilt or innocence.
Okay.
And then the state also changed the one about the subject of punishment to not say guilt or innocence,
Sure.
but to talk about the burden of proof. The state has also agreed to give the instruction on page 9 of our proposed instructions on the constitutional right of a defendant not to testify.
All right. So then what I think makes the most sense, tell me if I'm wrong, is just to go through individually. When there's no objection, just number that, move on to the next one, and organically raise the issues as they come up with the instructions. If there's something that doesn't get raised ultimately by the end, then I'll circle back and ask about the defense proposed.
I would agree with that, except for I don't think you want to number, if you do wind up giving the voluntariness, I don't think you want to number them after the last instruction. So
you want to
maybe
start
we
with
should address whether or
voluntariness?
not we should be giving voluntariness, and then when we get to the area where you want to argue voluntariness.
All right. Let's go voluntariness of statement as our first issue. Let me pull up the instruction that you have proposed. Defense. And then state has presented an alternate.
An alternate, but also an argument that there is no voluntariness that gets submitted to the jury.
Okay. So is the instruction that you are proposing to give the one from Vasquez-Reyes versus State and Colorado versus Connolly, Ms. Benedict?
No, I am.
That's the one that the state is proposing.
My proposed is from Carlson versus State, 84 Nevada 534.
If you actually just want to approach with yours, at this point, I don't know. It doesn't look like I received your entire packet, so everything. So I can just go through it printed. Thank you. All right. So the instruction that the defense is proposing three different instructions, correct?
I have 3 different options. The first one is directly from Carlson versus State. The second 2 are from instructions that I used as a district attorney.
All right. So what's your preferred one that I start with?
I'm happy with all 3 of them.
Okay, so you'll take any of the first 3. So
Well,
either
And definitely the second one on page 3 talks about the difference between an admission or a confession. So that one's different from the page 4 one, which talks about the totality of the circumstances and the voluntariness.
State, what's your objection regarding a voluntariness instruction being given at all?
In both the cases cited by the defense, and I recognize, both of them say where voluntariness of a statement is an issue, that you have to submit it to the jury. The mere fact that they filed a motion to suppress on voluntariness doesn't create an issue. They have presented, you have to, as Connolly says and Vasquez Diaz says, you have to establish some improper police coercion, and they have not done that in this case. The audio of the statements do not reflect any improper police coercion. Both of those, neither one of those have you found to be to be custodial. And so in both these cases, they're Mirandized statements of defendants who are in custody. There is a lot of law that, right, you know, if there's evidence of self-defense, you got to give self-defense. If there's evidence of a voluntariness, you have to give a voluntariness, voluntary manslaughter. There is zero evidence before this jury that they could factually make any sort of determination as to the voluntariness of the defendant's statements. By its very definition, a proffer cannot be involuntary because it is a negotiated contract between two people. So the only statement this could apply to would be the 2009 statement. And when you listen to the 2009 statement, it's clear there's not a single improper coercive conduct by Detective Long. Now, had the defendant got on the stand and said, hey, they beat me with rubber hoses before I went in the room, or hey, the cops told me this, or the cops told me that, or the cops told me this. The evidence before this jury is he was caught with PCP and a gallon of PCP and a kilo of cocaine. They told me I could be prosecuted for that, or I could give a statement. I negotiated a contract with my lawyer, with the government, to go in and give them a statement. By its very definition, it cannot be involuntary. And so if you instruct a jury on this, particularly the instructions they're requesting, it would be highly, highly confusing to the jury. And it's not an issue in the trial because they've brought zero evidence of coercion, improper police coercion, into this case. And because of that, I would say they're not entitled to a voluntariness instruction.
In reviewing the instructions that are proffered, Ms. Pender,
Can I approach to give you the two cases, Carlson and Morrison?
you may. My initial concern in reviewing what you have stated before I even get to the threshold matter of whether you've met, well, first I have to decide the threshold matter, but if we were to give an instruction, all instructions say that ultimately if a jury concludes that a confession or admission was not made voluntarily, then it's up to the jury to determine whether they should consider it. However, none of the three instructions give any insight to the jury as to how they would determine voluntariness. As a judge, when there's this motion to suppress brought up before me, in general, I have factors to consider. The jury would have none of those in the proposed instructions. And so it would be giving them a task that they have no way of accomplishing, essentially, is what is in front of me.
And what the defense is submitting in the Carlson case, they had an instruction that the Nevada Supreme Court ruled was sufficient in that case, and that is in the state's first proposed exhibit. And they actually gave the footnoted instruction of the fact that the court has admitted into evidence the alleged confession or admission of a defendant does not bind the jury to accept the court's conclusion. And the jury, before it may take a confession or admission into consideration, must for itself find whether or not it was voluntary confession or admission. If the jury concludes that a confession or admission was not made voluntarily, it is the duty of the jury to entirely disregard the same and not consider it for any purpose. That is directly from the Carlson
And
case.
they're saying voluntary carries a clear meaning without need for further definition or explanation.
That was going to be my very next
Okay.
argument, Your Honor. And they did say that it was error if the court did not give that instruction. And what they talked about was, and this is going to be something that's a theme running through all of our objections, there is a difference between admissibility and the question of fact that the jury now needs to decide. So here, Mr. DiGiacomo is absolutely correct that you have the initial determination of admissibility. You have ruled that it was voluntary. This will be an issue on appeal. This will be something that will be brought up by the defense should Mr. Davis get convicted. However, you also then are required by the Nevada Supreme Court to instruct the jury based upon their role now, which is determining whether or not there is evidence beyond a reasonable doubt. To me, that is how I read these Nevada Supreme Court cases, that you need to give these instructions. I do see the court and Mr. DiGiacomo's concerns. It is the defense position that we'd rather have all of the instructions given as opposed to just the state's. So I think it's better to instruct the jury than to not about all of the applicable rules. But I do think, and this will become even more important in the next argument about corpus delicti, I think that we do not need to instruct the jury on questions of admissibility. I do not want them to be confused about the proper standard that they need to decide, which is proof beyond a reasonable doubt. At this stage, it's a question of fact for the jury.
So let's work backwards then. Where in this record do we have evidence of improper police coercion, where we don't have, we have a statement that was given in the presence of police, or in the presence of his attorney that he brought there. We don't have any of the typical PSAMA factors present of, someone who's very young, someone who's very hungry, someone who's very tired, someone who's very susceptible to police coercion because of their lack of familiarity with the criminal justice system. We have none of those factors present here. Additionally, we have a defendant.
Would disagree.
But hang on a minute, and we also have someone who has not testified to explain a circumstance outside of those, outside of what is actually within the videos, and then ultimately no evidence that, apparently it would be difficult to know what to apply to this situation. But what is the, improper police coercion here?
Well, the defense, we all should not be arguing this right now. It's a question of fact for the jury. I'm not going to restate the evidence that we already heard at the trial, because it's up to the jury to decide.
You need to make a prima facie case.
Exactly, but it is our position that those factors, whether they've been met or not, would be up to the jury to determine. Both sides are going to have arguments and closing arguments that are going to be very different. This is one of the biggest issues in this case, and I think it's important to continue on to allow these instructions to be given as decided by the Supreme Court. I think it would be error not to give the instructions. And I think that there is some evidence of psychological pressure. That is going to be something that the defense may argue in this case based on the testimony at trial. But I don't think it's appropriate for us, because it's a question of fact for the jury.
But we need to get at least that there's something in the record to show, like if we're talking about voluntary manslaughter, you have to have at least that scintilla of evidence to get over that very small molehill. What evidence is there to give these voluntariness instructions at all, to get that first hurdle that Mr. DiGiacomo is, complaining about?
And I know that this court disagreed with the defense when it filed its motion to suppress the statements, but the defense detailed at length what the promises were. There were explicit promises made to the defendant in the 2008 proffer. There were implicit promises not to use it against him in the second 2009 interview. And those promises, while contested by the state and contested by the court, there was evidence of promises made to the defendant. There was evidence about confidentiality. that they agreed to keep. There was evidence about when that confidentiality was broken, who broke it first. These are all issues that are going to come up during closing arguments. And I'm sure they're going to be issues that are going to be deliberated by this jury in making a decision.
But none of that goes to voluntariness. Somebody violating something 5 years or 3 years afterwards doesn't change the voluntary nature of the statement. The person that, or the entities that contracted have never violated the agreement that was contracted. The contract was between Mr. Higgins and the U.S. government. The U.S. government never violated the contract. The suggestion that as a matter of law, you can never have an involuntary proffer. There would have to be some additional information that is elicited. The fact that they don't like what Mr. Kading did does not somehow change the nature of what happened 3 years before. And so the psychological pressures that they're talking about are exactly what U.S. Colorado v. Connolly say are not appropriate for purposes of the Sixth Amendment involuntariness. That is clearly not a situation where they're allowed to argue to a jury that because him and his family were wrapped up in a drug deal, that he somehow has the right to claim that his statements are involuntary. The Sixth Amendment is there to protect against improper police conduct. It is not there for this purpose. So when they use the term voluntary, he didn't have a choice. Well, he did have a choice. He could go to prison for the rest of his life on drugs. But he chose to make a statement to the police. And so there is no evidence of anything improper police conduct that has occurred here.
May I add something, Your Honor?
You may.
I wanted to clarify that the burden of proof is on the state to prove by a preponderance of the evidence that the confessions were voluntary. That is a burden of proof at the time of trial, not at the time of the motions. So in this case, they do have that burden to prove that beyond a preponderance of the evidence. So I think that's also relevant. And I think it's important in this case that we give this question to the jury based on the Supreme Court law that's in place. But as Your Honor well knows from all of the briefing in this case, there is very little law specifically on point to this issue. This is a unique issue. This is something that could create new law in the state of Nevada because there's very little law in Nevada that even remotely talks about the situation that we have in this case. And I think that it's very important to protect the record that the instructions be given. And I'll submit it to Your Honor.
Okay. I think it's safest to give some sort of voluntariness instruction to this jury, given the precedent in the Nevada Supreme Court, given the Carlson versus State case. I definitely agree with a lot of the state's arguments, and that's why I ruled the way that I did initially. However, it's clear that this has been an issue that has been raised by defense. It's something that they disagree with my ruling with pretty strenuously. And in the record, there is, that statement by by Detective Kading in that 2008 interview that this will never be used or this will never be heard, which was the basis for that voluntariness. I still think that wasn't the correct framework, but I think giving it ultimately to the jury is maybe a way to hedge our bets. So that being said,
And I'd ask you to
let's talk about the various instructions and how we're going to do this.
I would ask the court, and I will tell the court that, I cannot believe I'm actually going to say this, but I pulled those instructions on voluntariness from the Nevada pattern jury instructions. The only thing I did was conform up slightly to this case, to this case, and added to Colorado v. Connolly portion that says self-interest or an expectation of receiving a benefit does not make a statement involuntary. That isn't actually in the pattern instructions, but clearly it's the law, and that's why I sent you Vasquez Reyes, because Nevada has adopted Colorado v. Connolly. And so the instructions I gave you on voluntariness, and I'm trying to pull them up here because I didn't have them up on my computer initially here.
And so these are, your instruction is the pattern?
Is the pattern with the exception of the last line on the first page.
Okay.
I believe.
And so Ms. Pondick, the instructions that you've given me, obviously the one on page 2 involves Carlson and Lorson.
Yes.
Those are Nevada Supreme Court cases. The other 2 sites are simply for the stock CCDA brief bank instruction. Do you know where those necessarily come from? And if they were not incorporated into ultimately kind of the pattern, the idea was to incorporate those stocks into the patterns.
Those have been instructions that have historically been used by the district attorney's office that have been upheld by the Supreme Court. So those have not been challenged. Those haven't been, there have been no problems associated with those instructions. That was initially what I had asked the state to include that precipitated all of this.
Okay.
So I wanted to make sure that the court had those instructions. I agree with the state that their instructions are a correct statement of part of the law that applies. I'm not saying it's complete in terms of all the issues in this case, but as to the PASAMA factors, those are the factors. And I do agree that they're correct statements of the law. So we do not object to the admission of all the instructions, both the state's proposed as well as the defense proposed.
Well, the second 2 DA brief bank, I'll be honest with you, and then, you know, she was at appellate for a long time. Those are no longer in our stock instructions. These pattern instructions of what we've put into our stock instructions, because those are clearly, as the court noted, not adequate to explain to the jury voluntariness in a legal sense, what that is. And so if you're going to give the instructions, I would urge you to give the Nevada pattern instructions with the Connolly addition to them. But not, well, I mean, I think it's superfluous to even have the what is it, the Carlson Larson one, because these fully explain, these 2 instructions fully explain, hey, there's a confession and an admission. Here's what the difference between the 2 are. Here are the factors to consider in determining voluntariness. There needs to be improper police coercion involved in them.
I don't believe those 2 are sufficient. And I think that under Carlson, them saying that the term voluntary contains a clear meaning without need for further definition or explanation, that's also a clear mandate by the Supreme Court. But I would ask at a minimum.
Mandate from 1968.
Right. But there's been nothing.
In which the defense
nothing
was
new.
actually asking to give the factors to the jury, and the court said it was sufficient in 1968. But this is a very specific voluntary issue, right?
Okay. Turning back to Ms. Pondick, when I look at the instruction the state is offering, it does seem to incorporate what you've included for 3. It talks about what an admission is, what a confession is, and what the definitions are. It seems to be very similar language. And I think it was probably what was used to make the stock pattern, the stock instructions that the Supreme Court is encouraging us to use.
Yes.
And so it seems to be the predecessor to that. Would you agree with that?
Yes, it is fine to use both of those instructions.
Well, I'm just saying, I don't know that we need instruction 3 if that one is being given.
That's fine, Your Honor.
Okay?
I just want to make a complete record.
No, I understand. I'm just, if you agree with me that it's already incorporated in the instruction, I'm not going to give duplicates. So
Exactly.
3 doesn't seem to make sense. Page 3 doesn't seem to make sense. Page 4, let me compare that. I think page 4 does include additional factors, which include that the state has the burden of proving voluntariness by preponderance. But then it goes into the voluntariness being a question of fact to be determined by the and what you're to do if it is determined to be involuntary.
And I would ask that that instruction be given.
So I think 4 is incorporating your instruction 2. It has all the same features. So my thought is to give the state's instruction as well as page 4. And I'll let Mr. DiGiacomo be heard on that, just because it will avoid duplication of the exact same issues that could confuse the jury. Additionally, it includes an explanation to the jury of what to do to determine if it's when you determine it's voluntary or involuntary and who has the burden.
Okay, so you're going to give both of the states and then you're going to add 4?
Oh, the state has a second?
Yeah, the second
I haven't gotten to the second.
Yeah, the second one actually has all the factors listed out, and it does cover everything that's in her number 4.
Okay. Let me look at that one. I apologize.
Page 2 of ours, the passive factors.
The state, and it includes that the state has the burden of proving, which I indicated earlier was a very important part of instruction 4. I think ultimately in comparing page 2, it does encompass all of the ideas of page 4.
So instruction number 2 will not be given on page 2.
Right. I think what she's saying is she's going to take R2, it encompasses all 3 of yours. Is that what you're saying?
No, she's going to give on page 4.
Well, I didn't realize there was a page 2 to the state. What does the state's proposed either omit? I see that it adds the PASAMA factors, and you guys don't want the PASAMA factors given. Is that sort of the difference there?
I already said it was fine to give all 5 instructions, so I'm not saying that their proposed instructions are an inaccurate statement of the law.
Got it. Understood. So at this point, I'm going to give voluntariness instructions over the state's objection. However, I'm going to use the 2 that the state has proposed because they are pattern instructions, which we're encouraged to use. Additionally, in reviewing them and comparing them to the ones that were sent over by the state or by the defense, they do include all of the factors, as well as the fact that the state has the burden of proving the voluntariness by preponderance of the evidence. So I think they encompass everything that is necessary. They encompass the defenses, and to avoid confusion, I'm not going to give all 5. I'm just going to give the 2 that include the same ideas.
What about the one on page 4? You had said earlier you were going to give that one.
And I think that was before I knew that the state had given me even a second page.
Oh, okay.
So I was just looking at page
Okay.
1. I apologize. So now that I've got that. All right. So the voluntariness instructions will be given as proposed by the state. But to be clear, the state does not want voluntariness instructions. The other issue that we needed to address was corpus delicti. The defense is proposing on page 5.
And to be clear, Your Honor, the defense objects to the corpus delicti instruction proposed by the state. The only reason that we provided an alternative proposed instruction is because they included it in their packet. The defense objects to any corpus delicti instruction being given to this jury at all for these reasons. While the first attorney in this case had potentially raised a corpus delicti issue in his motion to dismiss, this defense team has not raised corpus delicti either in a motion or in front of this jury. That issue has not come up. It is a question of admissibility, not a question as to weight, and the defense objects to this instruction being given because we believe that it is confusing and misleading to the jury because their duty is beyond a reasonable doubt. And Their duty is as to wait, and it's confusing to even have this instruction. However, if the court disagrees with the defense position and will give an instruction, the case provided by the state, Sefton, that's actually from 1956, and the proper standard is the Doyle case. In the Doyle case, they provided, this is the exact instruction that comes out of Doyle, which is Doyle versus State, 112 Nevada 879 from 1996, Nevada Supreme Court. And that instruction is a more accurate statement of the law.
Your Honor, may I be heard?
Which one is your corpus instruction?
That is on page 5.
No, sorry, state. I'm on yours.
Okay.
It's near the end. Oh.
Give me the first couple words once you find it so I can,
Where independent evidence.
we're independent evidence. Okay, then I can control that then.
It's about 42 of 53. Although I may have I just added in the voluntary instruction, so maybe not.
So the instruction the state is proffering reads, where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. I don't know that that's necessarily a corpus issue.
It is, Your Honor. So this is what, and I'm going to disagree with Ms. Panduck with regards to the defendant's, the never taking the position that the corpus delicti issue. What Mr. Saft told the jury in his opening statement is, you have to corroborate what the defendant says. That is not the law. So the question is, when we talk about what's clarity to the jury, what is the law? The law is we have to prove when a person gives a confession, absent their confession, we have to prove, one, that a person is killed, two, by the criminal agency of another. But what Sefton says, and what even Ms. Panduck's case says, and I'll get to why that's not applicable here, but what even Ms. Panduck's case says is that once you've established there's a crime occurred, you don't have to corroborate any other aspect of a defendant's statement. Now, of course, they can give it to whatever weight they want. But
Isn't that the inverse, though, of what a corpus argument would be? Is that there is only a statement and nothing to back it up.
Yeah.
You're kind of inverting it.
No, this is what Sefton, this came up specifically in Sefton. In Sefton, specifically what happened was there was a dead body, the person confessed to the crime, and what the defendant argued is, well, you never independently corroborated my other statements connecting me to the crime, therefore it's a corpus issue. And what the Nevada Supreme Court held is that there's not a third prong to corroboration. There's one, death, two, by criminal agency, three, what the defense had proposed, and what Mr. Saft has proposed to this jury specifically is that the third thing you have to do is corroborate that a defendant's statements connecting himself to that crime are true. And I don't think there's any credible argument to say that that's not what Mr. Saft said. I mean, it's a direct quote from his opening statement, but that's not the state of the law. And what Mr. Saft, when Mr. Saft makes a argument that is an inaccurate aspect of the law, increasing our burden, we are entitled to an accurate statement of the law. And what an accurate statement of the law is that we do not have to corroborate anything beyond the corpus delicti. That is the corpus delicti rule, is that we don't have to corroborate anything beyond that. And so the question for this court is Mr. Saft, because he's certainly going to say it during his closing argument, and he said in the opening statement, is Mr. Saft allowed to give a false impression about the law to the jury? And the question of that should absolutely be no. Because in the absence of anything, with the absence of an instruction telling them that we don't, that the corpus delicti rule is that we don't have to, and even if you don't want to call it the corpus delicti rule, the rule is regarding confessions is that we do not have to corroborate anything beyond person being killed and the criminal agency. And so Miss Panduck, again, in Doyle v. State, the thing that she pulls is from a kidnapping case. from a kidnapping charge. But in another case that Ms. Pandek cites, West v. State, gives a very similar understanding of
You
the.
actually cite West v. State too.
Yes, well, she cited it, we cited it, we both cited it.
Yeah.
And the one thing that we can agree is the two parts of corpus delicti, the only thing that we have to independently establish is the death and by criminal agency. That's the only thing we have to establish. We don't have to corroborate anything else. And so the only question is the jury going to have to be, is the jury going to be misled about whether we have to corroborate or not? And what the instructions are there to do is to have them not misled as to what our burden is.
May the defense respond.
1 second, I'm not quite through with understanding the state's argument. Sefton states that you need, for a homicide, you need proof of corpus delicti, which we've always had in this case, right? No one ever,
Never challenge that. Well,
there,
not during the trial.
there have been challenges to which in the media as to whether Mr. Shakur is alive or dead, but in general, we've always had the fact that Mr. Shakur died that day and the body of the crime has always existed. And so corpus delicti wasn't really the issue here. It was the defendant's corroborating confession. Is that enough? And so,
Okay, so we can.
so I think that's,
So if you want to get rid of the first sentence where independent evidence established that the victim's death was caused by criminal agency another, that's fine. But a defendant's own statements admitting the crime need not be further corroborated as an accurate statement of law. And if I may read from Section B State,
okay.
it does say a conviction based on confession will stand, although it is uncorroborated otherwise by proof of corpus delicti. So what Sefton specifically says is we do not need to corroborate a defendant's statement. What Mr. Samf told the jury is we need to corroborate a defendant's statement. So the question before this court is simply whether the jury gets the accurate state of the law or they do not.
You may respond.
Thank you.
Ms. Pandek.
What the state argues is actually incorrect. The issue is regarding admissibility. So this instruction is only relevant for admissibility. If there was no corpus delicti, then none of the defendant's confessions could even be admitted at all. You would have been precluded from admitting them to even let the jury hear about them. What the defense's concern is now is that this is improperly impeding upon their duty to find guilt beyond a reasonable doubt. This is infringing upon that standard. There is absolutely no law that talks about the fact that you do not have to corroborate a defendant's confession in terms of a jury verdict with beyond a reasonable doubt as a standard. And I would like to use the example. There is one situation, that is the Gaxiola case. And the Gaxiola case, I believe, oh, here it is, I have the site. 121 Nevada 638 from 2005. The testimony of a victim of sexual assault does not need to be corroborated. And that is entirely different than the situation in this case. The confessions were admitted into evidence. That was correct. They absolutely can be admitted into evidence, but this instruction improperly instructs the jury that there's arguments by the state, arguments by the defense that they get to consider. They get to consider all of the evidence, and we cannot interfere with the burden of proof. So the state is wrong.
So, Your Honor, if I may be heard, like Sefton is not about admissibility. Sefton doesn't say this is about admissibility. It is about the threshold of proof, which is here. Now, if the court wants to add, it's still up to the jury to determine what weight to give to a statement. That's fine. But in terms of like the inaccurate statement of law being offered,
Where in Sefton does it say a defendant's own statements admitting the crime need not be further corroborated by evidence connecting the defendant to that crime?
Okay, it's if you do a Control F cert, F5 if you want it, if you're there.
Sure.
It says use conviction based on a confession will stand, although it is uncorroborated otherwise than by proof of the corpus delicti.
It doesn't cite to any other cases.
Actually, it does. In footnote 41, it goes on to say, it says, to this text, many authorities in support of this rule, and where corroborated evidence has been adduced, the rule is further stated. The corroborating evidence need not be such as to connect the accused with the crime. And then it goes on to say, hundreds of cases supports this rule and are cited in this note.
I believe Doyle supersedes that.
All right, let's look at Doyle.
And again, Doyle is
a kidnapping case.
They're talking about specifically a kidnapping case or kidnapping charge. It's a murder case, but a kidnapping charge is where the corpus comes
I don't think that matters.
Let's-
but not instructed in this case.
The West case that you guys both agree on, let's talk about that maybe.
Okay, well,
So that is clearly, that's a no body homicide, correct? Brookie West, right? That's
Yes,
what
there
you're
was
citing?
no body in that
Okay.
case.
So obviously a very different situation.
Yeah, that's just the two precedent factors that the state has to independently prove, which is the fact of death and the death occurred by the agency of another.
And I don't want to jump in, but she mentioned Gaxiola. Why would we be entitled to instruct a jury that a victim's sex assault cannot be corroborated, but we can't instruct that in a defendant's statement? Gaxiola supports the argument.
And this isn't an attempt to change the burden. If the court wants to add to this that, the state still needs to prove the case beyond a reasonable doubt, or it's up to the jury to give what weight it wants to give to the statements, that's fine too. But it is axiomatic that we do not have to corroborate a confession. And the law supports that position. And Mr. Samt has told the jury different, which is not true.
We need the proof of corpus. So really the argument here boils down to whether the defendant's statements need to be corroborated by any evidence, or in the case of the misconduct is stating it needs to be slight or prima facie for the kidnapping.
Well, that is regarding whether the crime occurred. That's not even about whether or not the statement.
Right, okay, because when in the kidnapping context, there's a situation where that crime could have not occurred.
Right.
There could have been no kidnapping whatsoever. It could have been a complete fallacy, a complete made up situation. Whereas when we're talking about a homicide, there is proof of corpus automatic within the body existing.
Correct.
Okay.
Doyle is just not used in kidnapping cases. That's the standard that's been used since it came out. Everyone cites to Doyle. Doyle is the standard for the corpus delicti rule.
Not according to West, which says the corpus delicti rule in Nevada is well established. To prove that a murder has been committed, the state must demonstrate the fact of death and the death occurred in a criminal agency of another. So that's what we got to establish. And then independently. And then the only question is, do we have to corroborate anything else or not? And the law is clear. We don't have to corroborate anything else. Now, of course, Ms. Panda does have a fair point. They're not required to accept it, but we're also not required to corroborate it. And that's the impression that the jury was given by Mr. Sanf when he said, you are required to corroborate it. We know that's not the law.
A defendant's statements essentially, if believed, kind of borrowing that phrase from Gaxiola.
Okay, yes, if believed, that is fine. I think that's fair. They don't have to believe it. I'm not trying to communicate that. I'm saying they don't have to believe it, but they don't have to corroborate it.
The defense still believes that also in West, it says corpus delicti must be established before evidence of a confession or admission may be considered to prove that the accused was the criminal agency that caused the victim's death.
Yes.
So the defense maintains this is a question of admissibility, not a question of fact for the jury. It doesn't apply. And
You
should not
just
be given.
stated that in order to get into the statement, you have to show that a crime has been committed. And the state did that because we have a body. That's literally the corpus. So a corpus is beyond approved, right?
Correct.
So
We didn't raise-
Brookie West is totally different because Brookie West, there's no body. And so how do we know that it's a crime? Those are all the issues. Here we have a body, always had a body.
I know, but I don't think the instruction should be given because it was not an issue in this trial. You
Corroboration.
admitted the confessions. This would be an issue to keep the confessions out of the jury's hearing. But here, they got to hear all the confessions. So now we're infringing upon the right of counsel to argue their case in front of the jury and the right of the jury to make the decision, the duty of the jury to make their decision beyond a reasonable doubt. This instruction should not be given at all.
All right, so
I'm sorry.
you might want to just listen for a second, Mr. Paul. Okay, so the state's instruction, I believe, is in reading through and reconciling it with Septon versus State, as well as the reiteration in the Brookie West case, is a correct statement of the law. However, I think the arguments of defense and everyone has been that these statements are not to be believed. And so I think the if believed language borrowed from Gaxiola adds that component in. So what I'm going to do on this instruction is say where independent evidence establishes the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime.
Your Honor, so you're going off of the state's?
Correct.
Can you do it a little bit slower, please?
Absolutely. I'm going to send you guys a copy of everything, but where independent evidence establishes that the victim's death was caused by the criminal agency of another, and just paraphrasing, that is directly from West, a defendant's own statements, if believed, admitting the crime, need not be further corroborated by evidence connecting the defendant to that crime.
Are you going to add any of this defense proposed exhibit, the defense proposed instruction?
So the defense proposed instruction says there needs to be slight corroborating evidence independent of any confession or admission, but that ultimately goes to the crime, to whether corpus is established. So the first paragraph the first line is literally saying where corpus is established, but explaining what corpus is. So I don't think that there's any way, given the court's ruling, to include that a slight or prima facie showing permitting the reasonable inference that a crime was committed is sufficient, because that would be impeding essentially on the corpus determination, which we've all agreed in this case is established. There need not be. And additionally, the final line of what this defense has proposed does say there need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confession or admissions. Is that something that you're seeking to have added, Ms. Panduct?
I moved to have the entire
okay.
instruction, and I would ask that any part of it still be given because I believe it is more informative and less confusing and misleading than the instruction that the state is proposing.
Okay. Any objection to the final line being added?
Yeah, I think it actually confuses the instruction as currently given. There need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confessions or admission. To me, is less clear than defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. I think our language is far clearer for the jury, and I think this is more duplicative than anything else.
I also believe that there should be a reasonable doubt admonition then as well placed in here. I believe this is still confusing to the jury, and the defense should be able to do the arguments as they intended.
What's the proposal to add a reasonable doubt instruction into this instruction? Or is that something that you
I would
believe
ask,
could be fixed by putting it close to the reasonable? Well, what are you asking?
no, I would ask that in this instruction right after here that it is up to the jury to determine the weight to be given to the confessions or admissions, and they must determine beyond a reasonable doubt,
I don't have a problem.
but definitely weight.
Yes,
It's up to the jury to determine the weight to be given any statement or any confession or admission.
I think that's a fair statement of the law, and so I don't have any objection to that.
All right, so that instruction will read as follows. Where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. It is up to the jury to determine the weight to be given to any confession or admission.
That's not the statement.
Okay. Obviously over objection, but incorporating some of the defenses, that is how that, suggestions, that is how that will be given. And then the final issue we have before we dive into just going through the instructions one by one would be the argument regarding self-defense. My initial reaction when you said this was self-defense is ultimately a defense. And so all of the instructions in Runyon go to the amount, or whether they're given, goes to the amount of evidence that a defendant presents and that a defendant argues. And I've never seen it given over the objection of the defendant.
Well, while I appreciate that, and I know Mr. Sampt has made a number of arguments to this jury, there is evidence of self-defense present, and the state is required to rebut that evidence beyond a reasonable doubt. Part of that evidence of self-defense involves him being the initial aggressor. So the jury has to know that while he may have asserted self-defense, let's say they only believe the book version, right? Or they reject everything else and only believe the book version. The book version is it was committed in self-defense, right? It's sort of like the mere presence instruction that's in here. The 2009 statement is more, I'm merely present at this particular event. Both the 2017 and the 2019 book is like Tupac shooting at us, so someone from the back seat started busting. Okay, well, Tupac would have been allowed to shoot at you. I know that there isn't a lot of evidence to support that, but the jury needs to be instructed on what the elements of self-defense are, because one of defendant's defenses, not Mr. Sam's, but defendant himself in his own statements, his defense is self-defense. And so we're entitled to have a proper instruction of that isn't self-defense. Even if you believe what he says only in the book, that is not self-defense.
But in order for you to tie Mr. Davis into this event whatsoever, there has to be an overarching plan already at the time that the self-defense came in.
I agree. That's why legally, right? Legally, he's wrong, right? He doesn't know the law of self-defense, but a lot of defendants give confessions and statements and go, hey, it was in self-defense when they ran up on somebody with a gun and that guy pulled the gun out and shot at them and hit the woman behind them, right? I mean, that case we have right now. That defendant says, well, I committed the crime in self-defense. Well, as a matter of law, you ran up with a gun on somebody, you don't get to claim self-defense. So the jury needs to be instructed on what the law of self-defense is, because there is some evidence of self-defense in the case. Whether the defense is going with that defense or not, whether Mr. Sampt argues it was in self-defense or not, isn't relevant. The law is, if there's evidence of self-defense present, the state must disprove it beyond a reasonable doubt. And since the defendant has asserted in at least two statements that the car was acting in self-defense, the jury's entitled to know what the law of self-defense is.
Remind me, does he actually say
He says the word self-defense.
self-defense, or does he say that, we thought he was going to get to popping or something like that?
No, at one point he says,
I'm confusing it with a different statement.
at one point he says, and I can't remember if it's in 2017, I think it's in the 2017 audio recordings, where he tells Mr. Diaz, yeah, it was in self-defense. He actually uses the word. I can word search the various statements, but when I heard that, that's what caused me to go, wait a second, we need to put an instruction in here because.
Okay, so I guess I see where you're coming from now. Defense, what's your position regarding this?
First of all, I would note that if the state brings these instructions in, they're adding to their burden of proof at trial, because they have then the burden of proving that the defendant did not act in self-defense. So I don't know why the state would want to add to their burden if the defense is not even requesting.
Leave that on them. You don't have to worry about that anymore.
That I don't understand.
Okay.
We're not asking for those instructions because we are not going to be arguing self-defense. We believe it would be confusing to the jury. It certainly is an accurate statement of the law under Runyon, but also under Runyon, it's up to the defense to ask for those instructions. I don't know of there being any case where the state can ask for them when the defense has not, but in the end, the defense will submit that to your honor.
Okay. Final word, state.
Yeah, it's in 2017 where Mr. Diaz is, so you're saying it's in self-defense is what really happened, and Davis says, yeah.
So Mr. Diaz says it.
Well, he uses the word self-defense, but I mean, the description of what Mr. Davis is saying is, hey man, Tupac pulled out a gun and started shooting at us, and so we had to shoot back. And so Diaz is saying, so you're now saying it's in self-defense, and the defendant says, yeah.
I mean, Ms. Pandak brought up a good point. I don't know why you'd want to take on a burden of disproving something that they're not even raising, but
Well, that's on me though, right?
yeah. All right, I'll give you the Runyon instructions. So we've gone through voluntariness of statement. That was granted. We're going to give instructions on that. Over state's objection, we've gone through corpus delicti. That was given over defense objection, and the self-defense is sort of, you're asking to take this on, and we're not sure why, but you want it, so we're going to give it to you. All right.
Also, for the record, I don't know if I made this record earlier, but there were wordings in the state's proposed instruction that I suggested making some additions, and the state granted that, and they made all the additions that I requested to other instructions. So I don't think we need to make a record as to those
Except
specific.
for she doesn't have those in front of her. I have been taking down notes of everything you said. I now have a clean copy with our instructions in order as it relates to the voluntariness. How about I save these, send them to the court, and we use those?
Oh, you don't do that in every other case. How come I have to do it that way? Anyway, okay, just kidding. All right, so at this point, I'm going to have you email all the parties with the notes that you've taken. We'll review them, and then we'll go through one by one, making sure there are no further objections. While you're doing that, any way you can make page 3?
I can't. I mean, maybe.
Yes, to
maybe
not go
Anne
forward.
can get page 3 to get that word off. I couldn't
got
figure
it.
out how to get.
Question on that: determine whether or not the defendant is guilty of one or more of the offenses charged.
Guilty, I guess,
Of the offense charged, because there's
of the
only one
event.
charge.
Yeah. Well, that'll solve it.
Okay,
Or just don't make it an extra.
Of the offense charged.
or make it small.
Guilty of one or more of the.
Okay, if you do guilty of the offense charged, it actually fixes the issue.
It does.
So
Let me
That was
save
just us
this as
being
the final.
style walks. All right. Send it over. That's charged. Okay.
Before I make sure I did put those Passimo ones in here. And there's self-defense. Come on.
So the one that you sent me at 9:13 a.m.
Didn't have the self-defense ones in them, or not didn't have the Passimo ones in place.
Okay.
So that's why I added those. Proffer agreement, statement made during police. Okay, yeah, they're in here. Okay, this is ready to go. I'm emailing it now.
Thank you. Do you have the Bolton instruction in there somewhere?
There is
On conspiracy.
multiple versions of Bolden in there. Do you want to send it? Do you want me to send it to Ann too?
No, I'm gonna print it out myself. And you're getting rid of the sites on the Sefton and West case, obviously.
Oh, did you have sites on there? Hold on a second before I do this then. Oops,
Is there a playback in here too somewhere?
there is.
Perfect.
Okay, I think it's good now. Let's see. Go back to join instructions. Insert. Okay, I think these are all right. People check. Mike, I didn't send it to you. I sent it to Megan. I sent it to Colleen and Megan.
How dare you?
Because I know you don't even know how to open your email.
Well, I have it open, just waiting for it right now.
Oh, well, you want me to report it to you right now?
No, I don't want to read it.
That whole law thing gets in the way of what we do. Words.
So then just do a final run through. I'll let you read through and make sure that that's what you've agreed to, or what you've all either, made a record on and I've ultimately made a determination of misconduct, okay?
Okay.
And then I'll number it if that accurately reflects what we've done here. Okay, so it is now my duty as judge. Any objection?
Judge, they don't have a copy.
Oh.
So, I mean, I emailed it to them, but they don't have a computer.
No.
So can we print a couple copies? We'll just do it manually.
That would be great.
Sorry, trees. Okay, did you get an email to you?
It's
Okay, I'm
totally
gonna forward
Colleen.
it.
You still non-green.
It is me. I'm very old school.
I'm just gonna go print and back. It's fine. I'll be back. Thank you.
You're welcome.
I'll give you a new copy of our thing. This is only the second trial where the voluntariness of the defendant's confession has ever been submitted to a jury.
Really?
125 trials in, only one other time have I had somebody ask for it.
I've always asked.
And in
I've
that
always
case,
included it.
the defendant did get on the stand and say they beat me with rubber hoses.
I've always included it.
you. Okay. Does anyone need clips?
I would.
I didn't bring it. Oh, I did.
I can give one to me.
Although it's like good, we gotta find the pen. We didn't plan on selling trees today.
One of you brought no pens, one of you brought no computer. There's something here, but, all right. I'm too tired to make the connection. Okay, let's go through then, one by one, and see if there's an objection. I will number them as we go, and then you will have a complete set, I think.
Thank you.
Okay. It is now my duty as judge. Any objection?
No.
No.
That'll be one. If in these instructions, any rule, direction, or idea is repeated,
No objection.
that will be given as 2. An indictment is but a formal method of accusing.
No objection.
No objection.
That will be given as 3. A conspiracy is an agreement.
No objection.
No objection.
That will be given as 4. It is not necessary in proving a conspiracy.
No objection.
That will be given as 5. Each member of a criminal conspiracy is liable.
No objection.
That will be given as 6. If one member of a conspiracy withdraws,
No objection.
that will be 7. Evidence that a person is in the company,
No objection.
that will be given as 8. When 2 or more persons are accused of committing a crime together,
No objection.
that will be given as 9. Murder in the first degree,
No objection.
I think that should be is a specific offense crime.
Yes.
That's correct. It should be.
Okay,
Is a,
Specific offense crime, not, yeah. No S on crimes.
yes.
murder in the second degree may be a general intent crime. Okay,
And that is number,
Actually, murder in the first degree is shouldn't it be specific intent crime?
Yes.
yeah, specific intent, not specific offense.
Offense,
a
yes,
specific intent crime.
yes.
And you're gonna clean these all up for the next time I use them.
All right, the next one, in this case, the defendant is
Is that
accused.
10, Judge?
That is 10.
Okay.
In this case, the defendant is accused in an indictment.
No objection.
That will be 11. Murder is the unlawful killing of a human being.
No objection.
That will be 12. Malice aforethought means the intentional doing of a wrongful act.
No objection.
No objection.
What number would that be?
13.
13. Okay. Express malice is that deliberate intention.
No objection.
No objection.
14. Murder of the first degree is murder.
No objection.
No objection.
That'll be 15. And now we're into the Byford series. The law does not undertake to measure in units of time.
No objection.
No objection.
That'll be 16. Although your verdict must be unanimous as to the charge.
No
No
objection.
objection.
17. The next one is you are instructed if you find the state has established.
No objection.
No objection.
That will be 18. All murder which is not murder of the first degree is murder of the second degree.
No objection.
No objection. Oh, I'm sorry. No objection.
Is that 19?
That was 18.
18?
18.
Thank you.
No, that last one was 18. So this
Okay.
is
Also, no,
19.
yeah, murder, which is not first,
Is second is 18.
No,
is 19. I'm sorry.
Is 19.
All murder is 19. We on the
Great.
same page?
The killing of another person in self-defense.
so we're getting these?
Yes,
Okay. I will rely on my previous objection.
of
for the
course.
record.
But you agree that's what we've agreed to essentially.
Yes.
All right, so that'll be 20.
These are correct statements. of the
These are
law.
all run-in. A bare fear of death, another run-in instruction will be given as 21.
Yes.
An honest but unreasonable belief in the necessity for self-defense, that will be given as 22. The right to self-defense is not available to an original aggressor, will be given as 23. Actual danger is not necessary to justify killing in self-defense, will be given as 24. The killing is justified even if developed afterwards, the person killing was mistaken, will be 25. If evidence of self-defense is present, state must prove beyond reasonable doubt defendant did not act in self-defense, will be given as 26. If a person kills another in self-defense, it must appear, will be given as 27. And then we're out of the run-in series.
Okay.
Okay. Then we're into the deadly weapon enhancement. You're instructed if you find defendant guilty of first or second degree murder, you must also determine whether a deadly weapon was used.
No objection.
No, but 28.
That'll be 28. Deadly weapon means
No objection.
29. That's 29. State is not required to have recovered the deadly weapon.
No objection.
That will be given as 30. If more than one person commits a crime,
No objection.
that'll be given as 31. To constitute the crime charged,
No objection.
that'll be given as 32. Defendant is presumed innocent.
Can we slow down just a little bit? You're faster than my fingers.
I just wanted to make sure we took out this one word. Okay, no objection, as revised. 33.
That'll be given as 33.
Yes, sir.
You guys have met and conferred about that and come up with this.
Yes, we took out the word material pursuant to the Burnside case.
That's
Okay,
correct.
perfect. You are here to determine if defendant is guilty.
This was an instruction that the defense offered a revised version and the state agreed. So
So this will be given as 34 as
Thank
modified.
you.
The evidence you are to consider in this case,
no objection.
that'll be given as 36.
No, 35.
35.
35, Judge.
Thank you. That'll be 35. It is a constitutional right of the defendant. He may not be compelled to testify.
No objection.
And to be clear, you are requesting that.
Yes.
Okay, that'll be given as 36. You heard evidence regarding drug trafficking, federal convictions, and gang affiliation. This is our Tavares instruction, correct?
Correct.
Yes. Okay, that one will be given as 37.
And Your Honor, just for the record, similarly to some of the other ones, Ms. Panduct asked us to revise it a little bit, and we agreed to her revisions.
Okay, perfect. Thank you for putting that on the record. The next one is a proffer agreement is a contractual agreement between a sovereign and a defendant that obligates the sovereign and the defendant to its terms.
Your Honor, we discussed this. My concern was with the word sovereign, that the jury may not understand that. And so there was some discussion about changing that word to jurisdiction or government. But
How about like a specific government entity? Is that better or? But I mean,
I don't know if the court has a similar concern.
Sovereign always reminds me of a sovereign citizen. which
I know.
is other things, but,
You can use whatever term, like a specific government entity.
okay,
I think that would be better.
all right. So if you guys want to replace the word sovereign with specific government entity, it does. So it would read: a proffer agreement is a contractual agreement between a specific government and governmental entity and a defendant that obligates that government entity and that's defendant to its terms, wherein both sides of the contract expect the benefit in exchange for entering into the contract. It does not bind any other government entity. In this case, you have heard that the defendant entered through. Do you want to spell out count through?
Oh, yes, it should be spelled.
Instead of like a drive-through at McDonald's, like the actual way the word is spelled, guys. All right. Through counsel into an agreement with the United States government, the state of Nevada is not bound by that agreement. So there's no objection to that with the replacement of the word sovereign.
Yes,
Okay,
that is.
I'll give that one as 38. A statement need not made by the defendant himself to be considered his own statement.
No objection.
That will be 39. Statements defendant made during a police interview. That is,
Okay.
This is going to be 40. We have discussed it. Your prior objections stand, but ultimately your request for instructions on voluntariness are acknowledged and given.
Thank you.
All right. And then the next one,
Just for the record, the state does.
and the state
Objects
objects
to
to the
the
giving
vol-
of them, but got their wording.
Correct.
Okay. So that was given as 40. And then the next one is in the same vein. In making a decision about the voluntariness of a confession or admission, this will be given as 41 pursuant to our previous argument. The next one is where independent evidence establishes.
Let me read this more carefully.
This is the corpus one. We called it corpus, but I disagree. It's really corpus.
call it the corroboration.
Corroboration instruction, let's call it that.
Our objection stands.
Okay, but you agree that's what we
That's the
decided
one
on.
the court decided on.
Okay, so that will be given as 42. Previous objections are noted. The next one, wherever there's slight evidence that a conspiracy existed.
Okay, I usually put this one earlier, but let's just keep it like this. Okay, 40, no objection.
That'll be 43. In deciding the facts, you may have to decide which testimony to believe.
No objection.
This will be given as instruction 44. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation as an expert witness.
No objection.
That will be given as 45.
Wait, hold on.
Although you are to consider only the evidence in reaching a verdict, you must bring your common sense.
No objection.
That will be given as 46. During this trial, you received certain audio recordings.
No
And
objection.
It explains that the audio recordings are the evidence as opposed to the transcriptions, which may contain errors.
No objection.
That'll be 47. The next one is you may not discuss punishment.
This is one that I asked for alternative language to be used and the state agreed.
Okay, so as modified, it will be given as 48. When you retire, you must select a foreperson.
No objection.
That will be 49. In your deliberation, you desire to be further informed on any point of law.
Objection.
This is the playback, so
Hold on. So 50, no objection. No 51.
you need the instruction in there that the jury is not to test any theory of the case, etc.
Yeah.
Oh, yeah, I always forget that now. There's a court rule for that. So maybe we should add that before 51
Okay, let me pull up
or make it 51.
the ones that I've used for previous cases.
Wait a minute. Hold on.
Oh, okay. I'm realizing at this point that we're missing ones.
I feel like we're missing one too.
We are, and she's grabbing it. It's the one where they're not supposed to do any research or look on social media and all the other stuff that the court requires us to do.
And I haven't finished with going through them, but I realized at that point that we were missing that one. The Bowman instruction.
Which is going to be 51. I'll add it as the jury. Page break. I think the court typed that one for me in our last trial. Let's see. Aubrey? I have to bring up
Please don't mention that right now.
that.
He's in that one.
Those instructions were great.
Yeah, where is that one?
Ask him. Hey, do you guys have the credibility instruction in there?
Yeah.
Yeah, it's the lengthy one. It's not the short one.
All right, so the
Okay,
Bowman
we wanted the
instruction
short
needs
one
to be
again.
given, which states, during deliberations, other than deliberating with each other in the deliberation room, jurors are not to communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. Read, watch, listen to any news or media accounts or commentary on the case. Do any research such as consulting dictionaries, using the internet, or using reference materials. Make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own. Any objection to that wording of the Bowman instruction? I think
Which
that's
instruction is this?
it's the instruction from.
Which number though?
It
I'm
will
gonna
be
have to add
51.
it in. We don't have it. It's from Bowman versus State. In 2016, the Nevada Supreme Court indicated it was. First of all, that I had to read the admonition that I do every single time they leave
Could
the
you
room.
restate it? I just noticed a
Absolutely,
missing
yes.
instruction that I thought was in there.
Okay, during deliberations, other than deliberating with each other in the deliberation room, jurors are not to, 1, communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. 2, read, watch, or listen to any news or media accounts or commentary about the case. 3, do any research, such as consulting dictionaries, using the internet, or using reference materials. 4, make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own.
No objection.
Okay,
And what number? That's
We could just make it 51.
and then I'm emailing it to you, Mr. DiGiacomo.
Oh, I just, the beginning of the one we used last time was slightly different. So it's during deliberations. Just review that, and I have it in here already.
During deliberations, other than deliberating with each other in the deliberation room Jurors.
Deliberating
with each other
other
in the
deliberation
room,
Comma.
jurors are not to, colon.
Or not to.
do
Okay.
all the things. Okay, so that'll be 51. Is that the idea?
And then the
That would
last
make
one will be
sense.
52.
Yes, so we'll put the Bowman instruction as 51, and then 52 will be, now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict.
I just,
And that would be 52.
there was an instruction that was omitted from these. So the state presented a different credibility instruction.
Okay.
But I thought that this one, which is a stock instruction, would be included, and I see now that it is not. It's the credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe that a witness has lied about any material fact in this case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. That is a stock instruction.
Any objection to using that instruction as opposed to the one that you've included? It's
At 44. If you want to replace that in 44, I have no objection to
Okay.
that.
And I also don't mind using both of them.
Well, I mean,
We
there's
need one.
duplicative. We need one. So if you want to
if
use,
that's your request for that instruction, Ms. Pandak, that's the one we'll use.
Thank you.
If you want to just give that wording to Mr. DiGiacomo. Or he has
I
to
actually
type it
can
up.
get it
Can you
because
get it?
what
It's the one
happens?
he's used
What
in
happens
every,
is the court.
he's used that in every other trial and objected to this one, but today he decided to switch it up on me, so
Yes,
I'm glad I saw it.
you're fine. Okay,
just because I stole these instructions from ones you made me do last time, so I'm like, I'm not even gonna fight this time. Ability of a witness should be determined by his manner upon the stand. His
Oh. Okay, so while he's working on that, the state has proposed the verdict instruction, so the verdict form, so I assume they have no objection to it. Ms. Pandak, any objection to the form of verdict?
Mr. Samt had requested that not guilty be listed first. I told Mr. Giacomo he did not agree.
we object.
In general, in most cases, I have no objection to doing it that way, but because of the way that the step down instruction works, it makes sense in homicides to have it in this order. And so I understand the objection and I understand why it's been upheld multiple times going in the descending order. Essentially, it converts the step down instruction to a step up instruction. And so that's generally why I don't do it in these cases. But all right, so other than that objection,
Yes.
the crimes included are the crimes you're requesting to be.
Yes, we did not request a voluntary manslaughter to be.
Okay. That's on record. All right, Mr. DiGiacomo, then do you have everything added to yours?
I'm still typing that, Judge.
Okay, perfect.
But as soon as I do, I will send it to you. Material. The case made entire test of that witness or any portion of this test which is not proved by Okay, I think save as, final numbered, and I can send this around to everybody.
Okay, sounds good. Anything else we need to address while we have this time before we do closings on Monday?
We'll be at 9 o'clock as opposed to 9:30.
We hope.
I think the idea is we're having everyone get here at 9, but if we ultimately start a little later, that may be what ends up happening. But I also have to read instructions, which takes about, well, with 52 instructions, we're thinking maybe 20 to 30 minutes. So I don't think that we would be starting actual argument until about 9:30 at least. Mr. Sam?
I'm sorry, Judge. I don't remember in this department. Do you give each one of them a copy of the instructions to follow along with?
So what I do is I read the instructions to them and tell them to write down the ones that they want, and then we give like 6 copies in the back.
I see. All right.
Okay.
Thank you.
Anything else?
Nothing from the state, Your Honor.
Nothing from defense?
No, Your Honor.
All right, we'll be in recess. We'll see everyone back on Monday for closing arguments. Thank you, everyone. Have a good weekend.
Thank you.
Hey, we always appreciate the support, and if you guys want to do so, you can use the Cash App or PayPal links. They'll be in the description box below this video or pinned at the top of the comments. The top donators will be announced every month. All right, you guys, hope y'all enjoyed the video. Like, share, and subscribe. Make sure y'all cop the merch, and make sure that you get the weight loss formula. The links to that will be in the description box below this video. Check out our next video coming up right now.